Yes.
May I please, Your Lordship?
Hmm.
I pray for listing of a matter tomorrow for motion, Lordship.
Why?
Agency is there, Lordship, because the Safai Karmachari has given a notice of strike.
Hmm.
So we have filed it on one tomorrow, Lordship, for
Hmm.
motion. Public.
My lord, I am praying for promotion matter, Lordship, on tomorrow, because eviction process is going to be carried out by the day after tomorrow, Lordship. Already done.
Please, Your Lordship. Your Lordship, I'm praying for listing of a matter on Friday, Your Lordship. Motion.
Motion. What is the urgency?
Protection, Your Lordship.
May I please, Your Lordship? My lord, I beg to mention for seeking adjournment in item number 42, my lord. I have to file rejoinder, my lord.
42.
42, my lord. Only 1 week time, my lord.
Hmm.
1 week time, maybe.
Mr.
AHMR Chaudhary.
Mr. A.H.M.R. Chaudhary. No, on the prayer of Mr. A.H.M.R. Chaudhary, learn counsel for the petitioner, list this matter after 2 weeks.
1 week only.
1 week. After the week.
Please, Lordship. Lordship, with the consent of the other side, I beg to mention item number 16.
6.
16, 1 6.
Ah,
And we adjourn the matter for the day, Lordship.
it's a part-hard matter.
Lordship, my senior is out of the station, Lordship.
You'll release from the,
Friday.
you'll release from part-hard in that case. Will release from the part-hard.
Lordship, last time, Lordship, fix on Friday, Lordship.
Not Friday. Tuesday, next Tuesday. On the prayer of Miss M.S.
P. Rava, on behalf of Sega.
We learn counsel appear on behalf of
A. Gayan. A. Gayan.
again learn this CGC for the respondent list this matter after the week.
Wait, Your Lordship. Lordship, I have filed an additional affidavit in item number 49. That may be called for.
49?
Yes, Lordship. I have filed an additional affidavit, Lordship.
Hmm.
That may be called for, Lordship.
Additional affidavit.
Yes.
Yes, call.
I'll you.
Please call.
May I please, my lord? My lord, I beg to mention item number 46, my lord.
Hmm.
My lord, I am appealing for the respondent number 4 and 5. My lord, in this case, respondent number 4 perhaps expired. So I have to take the instruction, my lord. Let it make after 2 weeks, my lord.
On the prayer of Mr.
A.K. Gupta, my lord.
A.K. Gupta, learn counsel for respondent number 4 and 5. List this matter after 3 weeks.
Hello.
So as to enable him to obtain instruction.
May I please, my lord? I beg to mention for listing of 3 read petitions tomorrow, Lordship.
Hmm?
3 read petitions, Lordship, tomorrow.
What is the urgency?
Lordship, Honorable Division Bench has already disposed of the matter, so
Ah.
this matter is also covered, Lordship. It can be disposed of, but
When?
Lordship,
When?
tomorrow, Lordship.
Tomorrow is it possible?
Lordship,
Next week?
Lordship, tomorrow, Lordship.
Why?
It's already covered matter, Lordship.
Are you sure?
Yes, sir, Lordship.
Okay. If it is not covered, we'll impose a cost on you. Hmm. Tomorrow.
May I please, Your Lordship?
You have to give the mention memo
Yes, sir.
indicating the date. Hmm.
Lordship. May I please, Your Lordship? With the consent of the other side, I beg to mention item number 43 and 44, Lordship.
43 and 44.
Okay, in this matter, I require 10 days time to obtain instructions, Lordship.
Okay.
I am waiting for the petition. I have no objection.
Mr. On the prayer, Mr.
KJ, Lordship.
K. Jain, learn counsel appearing on my learn standing counsel CGST. List this matter after 3 weeks. No, this separate. It will be separate order. Huh? 43 and 44.
Same, Lordship, similar matter.
And prayer not being objected to by learned counsel for the list this matter after 2 weeks.
10
2 weeks.
10 days, Lordship.
2 weeks. Make it 2 weeks.
Lordship.
Hmm.
Much
Separate order.
May I please, my lord? But I beg to mention item number 27.
Hmm.
But this matter may be adjourned for today and we come after 4 weeks, my lord.
Why?
And we have to file an additional affidavit, my lord.
You are for petitioner.
Petition, yes, my lord.
On the prayer of Mr.
P. Decker.
P. Decker, learn counsel for the petitioner. List this matter after 3 weeks. So as to enable him to file additional affidavit.
Yes, ma'am.
Hmm.
I please, Your Lordship.
Also, with the consent of the other side, back to mention item number 26, Lordship.
Hmm.
Also, we have to file a reply to this, Lordship.
On the prayer of Mr.
A Mena, Lordship.
Huh?
A Mena, Lordship.
Your name is not there.
On behalf of F Khan, Lordship. Because
A. Mannan.
Mena.
Mena, Land Council appearing on behalf of Mr. F. Khan and Council for the petitioner has released this matter after 2 weeks so as to enable the petitioner to file the affidavit in reply. Yes.
Lordship, I'm appearing for the amicus curiae.
In this
Mr.
case?
H.K. Das, Lordship.
Ah,
I'm appearing on behalf of Mr. H.K. Das for the amicus curiae.
Lordship, interim is there, Lordship. Interim.
interim order passed earlier shall continue.
May I please your lordship, I want to adjourn matter 36 to 40.
Hmm?
I want to adjourn matter 36 to 40.
6?
36 to 40.
Huh?
Taken.
You want to adjourn?
Yeah.
You adjourn it, why permission is required?
No,
If you want to adjourn it, adjourn it.
lordship, I want to say that I want to take adjournment.
Hmm?
I want to take adjournment.
That's why I'm saying, if you want to take adjournment, you take it. What permission is required? Anyway, on the prayer of Mr.
Mr. Ma'am, on behalf of B Das, on behalf of you Das.
You are Bidas.
Yes.
Hearing on behalf of you Das. List these matters after 4 weeks.
No, 2 weeks.
2 weeks. Huh? No, make it 2 weeks.
May I please your Lordship?
Yes.
I beg to mention item number 25, Lordship.
Ah,
We have already taken the consent. Lordship, matter may be adjourned for today, Lordship.
25. Okay.
Lordship, I am appealing for the respondent number 567.
Ah,
There is an interim order operating. A short date may be given.
2 weeks. Huh?
Lordship, date may be fixed.
On the prayer of Mr.
Yes.
Miss. Huh?
As Bashar.
Yes, Basak, and counsel for the petitioner release this matter after 2 weeks. Next
Interim,
para, Mr. RJ Das, learned counsel for responsible 5, 6, and 7 is present. Interim order passed earlier shall continue. List on when?
Lordship, any date, 16, 18, date.
No, after 2 weeks.
Lordship, it's 2 weeks only.
Hmm?
Today is third, the second. So Lordship, then 23rd,
23rd.
deeply obliged.
obliged.
Make please Lordship, praying for listing of 3 motion matters is covered by Lordship order. Friday, Lordship permits.
Not Friday,
Monday, Lordship,
Monday.
deeply obliged. May it please your Lordship.
Yes.
My lord, in this case, my lord, I have a two-fold of prayer, my lord.
Hmm?
One, to quash the, my lord, speaking order dated 19/9/2019,
Ah,
and alternatively, my lord, for resettlement under Assam Land Policy 2019, my lord. If your lordship come to page 81, my lord, this is the third round of litigation, my lord. In the second round of litigation, this honorable court passed the following order, my lord, at page 81, the
Yes.
order dated 93/2025, my lord. Para 2. This petitioner earlier approached this court by filing WPC number 4654 of 2019 challenging the eviction notice dated 35/2000 by which they were sought to be evicted for allegedly occupying government reserve land. It was projected of the petitioner in the.
no time to hear this thing. It's
My-
for disposal.
Yes, my lord, it was disposed of.
No, it is disposal.
No.
Matter is listed for disposal.
83, madam.
Huh?
It says accordingly a present writ petition sent closed with a liberty to the petitioner to approach the appropriate forum.
Appropriate for my lord. Therefore, my lord, I have filed this.
However, taking note of conduct of the respondent is not disclosing the aforesaid order. It is provided that the petitioner shall not be evicted in pursuance of the order dated till 90 days or till filing an appropriate application or till consideration of such application. Date may be filed whichever is earlier. My lord, this is a order of 25, 19/25. 90 days already been covered. Whether they have filed an appropriate.
Yes, we have filed the appropriate, my lord, petition within 90 days, my lord.
Where it is?
That is, my lord, at page, my lord, 85, NHR 18, my lord. To the circle officer, North Lakhimpur Revenue Circle, my lord. We also annex the Honorable High Court order dated 19/3/2025, thereby explaining, my lord, everything.
Where is the receipt? Where is the
There
acknowledgement?
my lord, given one number 478 at page, my lord, and received 13/6/2025.
Hmm.
One number given.
Then?
And thereby I have, my lord, narrated everything about the speaking order, my lord.
Then?
That speaking order was, my lord,
Then?
then, my lord, if your lordship come to page 104, the speaking order itself, page 104, my lord. After much persuasion by this honorable court, they have filed the, my lord, speaking order before this honorable court.
Hmm?
After much persuasion from this honorable court, they have filed one copy of this speaking order before this honorable court. And one copy was also furnished to us, my lord.
So where it is?
It is at page 106, my lord, is the original copy, my lord.
106.
104, my lord. Sorry, my lord. 104. Annexure 22.
Hmm.
Where if your lordship see that there is no seal, my lord, no one, my lord, only.
What does it? You are challenging this?
Yeah, this, my lord, yes.
Then?
No, my lord, seal, no full signature, who signed it, my lord, even serial number is not there. If Hague order was passed, my lord, and not, my lord, discuss about the, my lord, legitimate right, my lord, over the land. And that, my lord, eviction notice was also given by the circle officer, which is not permissible, my lord. As per the honorable court order also, the deputy commissioner, my lord, is the competent authority, my lord. I have the, my lord, citation of this honorable court, my lord.
What is this? This is passed by whom?
Circle officer, my lord. If your lordship come to para 8, my lord, last 3 line, my lord, also. Olga Telly Chopra and Nothing. It had that third contention raised in that in the decision of the Supreme Court, Olga Tellis and other versus Bombay Municipal Corporation, it had provided that even the street hawkers do have some legal right, and the last contention raised is that the power to eject the petitioner from the government land would be on deputy commissioner.
Where is the law?
Law is, my lord,
Who can evict?
my lord, my lord, rules under Assam Land and Revenue Regulation 1886, ejectment rule, my lord. Rule 18, 3A. In all other cases, ejectment shall be preceded by publication of a notice in the manner prescribed below, requiring the occupant generally to vacate the land, especially in the notice within 15 days of the date of publication. 15 days was not given, my lord. The notice and to remove the building, house, fence, or which may be raised at the land.
What is your right?
Provided that the deputy commissioner may give time to the particular occupant of the harvest of the crop penny. So, my lord, in that judgment also it is specifically mentioned, my lord, that the deputy commissioner may, that para, my lord, 9, my lord, at para 9, my lord. Last 3 line, my lord. As regard fourth contention, it is for the deputy commissioner to issue the order. We are again accept the contention of the petition. And in para 10 also, from the said point of view, notice dated such and such are interfered, the respondent in the deputy commissioner Jorad is directed to issue fresh notice to the petitioner and give them an opportunity of hearing to present their case and complete the proceeding and pass a reasoned order thereof as to whether the petitioner required to be evicted from their encroachment government land.
You are heard or not?
My lord, I was partially, I was heard, but that speaking order was not given to me. After my RTI also, I have filed one right to information, my lord, RTI application. Then also they deny that we have no information.
Heard, Mr.
And Sarkar.
My lord, 104 will very much be clear, my lord. Page 104.
No, we'll just issue notice. That's all, nothing. Are you Have you
It
started
says-
construction?
It says, my
Have
lord,
you started the construction?
Bhumi Pujan has
Yes,
taken
my lord.
place, my lord.
Bhumi Pujan, they have already.
Let them go on. So we will continue.
My lord, it says, my lord,
Heard Mr.
And
and
Sarkar.
Sarkar learn counsel for the petitioners. How many petitioners?
There are my.
12
Uh,
petitioners.
12.
Uh, challenge made in this writ petition is to the order dated 1909-2019.
No, my lord, 20.
19, it's a 19 order, my lord, 104. It says, my lord, but the petitioner have to
2019.
file any written
Thereafter, my
objection
lord,
along with the
petition was
application.
filed
date.
before this.
2019 passed by the circle officer.
Yes, my lord.
Huh?
Not looking for revenue, sir.
Circle officer, not Lakhimpur Revenue Circle, whereby the application of the petitioners pursuant to the order of this court has been rejected on the ground that rejected application application pursuant to the order of this court for settlement of land occupied by the petitioner under DAG number 704 at fourth part of pub Chanmari, Lakhimpur has been rejected. Huh? Next paragraph. It is the contention of the petitioners that they are in occupation of the aforesaid land since 25 to 30 years and therefore are entitled to be settled with them in terms of the what in terms of the
My lord,
provisions
Assam
of,
land policy in 2019, my lord.
in terms of the Assam land policy 2019 issue notice returnable by 4 weeks. You are appearing for all.
No, my lord, 3 and 4.
You are both of you are representing all. Since Miss MS N. Bordole, learned Standing Council Revenue Department, and Mr. N. Das, learned State Council, and this appearance accepts notice on behalf of all the respondents. No formal notice need be. So have extra copy will be furnished to yourselves.
My lord, I have only one prayer, my lord, at page 83, my lord, this honorable court has directed them. It is provided the petitioner shall not be evicted in pursuance of the data 19/9/2008 till the 19 day. 19
No,
days.
your
And my lord, before
wait,
19.
just wait. This order was passed in 2019.
Thereafter, I approach, my lord, this honorable.
Much water have already flown.
My lord,
We'll
this
see.
honorable court pass order to stay the
We'll see.
whole thing, my lord, for 90 days. Before 90 days, they demolished my house as well.
It's already demolished. What can we do now?
My lord, just for not further.
Can we turn the clock back?
No, my lord, not only further
More
construction.
so the
Why not, my lord? It's
more so what do we call it? Bhumi Puja.
Yes, my lord.
Has already
Pujan, but
Bhumi Pujan already undertaken.
yes, my Pujan is there, my lord. My lord,
What
only
right date?
It's a waste
Admittedly, it's a
for
government land, my lord.
public purpose only.
no.
What is called waste management? What solid?
My lord, they have now.
Prayer is for resettlement.
Yes, my
Except
lord.
that prayer is for
Yes,
resettlement.
there is.
Now, how can they stop
Okay,
that?
thank you. Next. 4 weeks.
Much obliged.
You have already filed the affidavit. Who has filed the affidavit?
Oh, my lord, there's an additional effect filed by them.
Yes,
Okay.
obliged.
Extra copies, but.
Yes.
Extra copies.
Yes,
No,
ma'am.
no, no.
Yes, ma'am. I'll. Item 2.
Please, your lordship. Lordship, this matter pertains to the debt compensation of the petitioner's husband, your lordship. Petitioner's husband had died, your lordship, on makeshift camp at Tilavil, Goalpara, your lordship.
Heard Mr.
M.H. Ali, your lordship.
M.H. Ali, learned counsel for the petitioner. this application is filed seeking inter alia, seeking filed, comma, essentially seeking compensation for the death of her, the death of petitioner's husband, late Tazim Khan or Khan, Kha or Khan,
Hi, your
Kha,
Kha.
K-H-A,
yes, sir.
Kha, on the alleged, on the result of alleged inhuman conditions pursuant to the, on account of eviction drive at Baluk Dubi Hasila Bill. List of issue notice returnable by 4 weeks. This is which place? This bill is which place?
Gwalpara, your lordship.
Gwalpara, huh? Next place, Gwalpara. Next place, issue notice returnable for 4 weeks.
Lordship, this matter may be taken with another petition. your lordship.
Yes, Miss Burma. Are you appearing for all?
My lord, 4 and 5 are there.
Huh?
Respondent number 4 and 5.
Who else are there?
Revenue is also there, my health, family welfare,
Hmm?
health, family welfare is also there.
Who is family welfare? Why family welfare?
Names are not shown in the cause list, my lord, only GI.
Who is 1, 2, 3?
One is I am appearing, my lord. 1, 4 and 5.
1, 4 and 5.
2, 3 is revenue, my lord.
Revenue. You record your name and so and so, so and so. Who is health department? Health department.
Names are not shown, my lord, from the data. Madam, please go.
You furnish the extra copies.
Yes, sir.
Follow me.
Lordship, this matter may be taken with WBC 281926, your lordship. Similar matter, your lordship.
One is for, you are 1.
One.
M. Burman landed statement for 1, 4 and 5, comma, then 2 and 3, MS, PR Mon, then, and T. Bora, P. Bora, D. Bora. Standing counsel, health department, for so and so, huh? No formal notice, so and have. Extra copies, so and so. 4 weeks, returnable 4 weeks.
Obliged, your lordship.
Registry to reflect the name of the landed council for landed standing council. Assam, what is it? Health and family welfare, revenue and revenue, this is so and so. In the cause list, huh? List along with requisition.
WBC 281926, your lordship. Obliged, your lordship.
Item 3.
Yes.
But here, in this case, there is a initiation of 2 parallel proceedings of the same period of financial year. One, the superintendent issues a so-called notice, page number 34, my friend, demanding 16,95,007.
Which one order you are challenging?
This so-called notice and original issued by under the so-called notice and recovery notice.
And where it is?
Page number 34, so-called notice.
34 is so cause.
Yes.
This
And
is
this is so-called initiated
demand comes so cause.
superintendent demand.
Huh? Then
Again, order in original 46.
page number 46, confirming the demand arising out of the so-called notice.
Page,
46 and again the recovery
page,
notice.
page 46.
Yes, my lord.
This is what?
This is order, adjudication order arising out of the so-called notice. Demanding 16,95,000. And
Huh?
subsequently, there is a recovery notice has been issued at page number 69.
Then ultimately,
My lord, here actually two
You-
proceedings are continuing. One superintendent central CGFD
okay,
initiating the for 4 months for period
then
December.
page 69,
Yes,
then
page number 55. Recovery notice.
55.
Yeah, my lord.
Then
These three documents we are challenging, actually these are not maintainable under the Central Goods and Service Tax 9.
Don't you- there's no appeal provision.
My lord, here, no. Here, actually, there are parallel procedure initiated. At first, superintendent issued the so-called notice. Simultaneously, audit commissioner issued the audit notice for 5 years,
Hmm.
starting from 2017-18 to 2021, 23-24,
Hmm.
for 5 years. And they conducted the audit, they verify all the documents for
Hmm.
5 years, and all the audit paras, whatever raised, that
Hmm.
has been accepted by the petitioners.
Hmm.
And that subsequently the audit para, final audit para was dropped. My lord, page number
This order dated 18/12/2020 is not available order.
my lord, that is applicable order,
Then,
but meanwhile, audit proceeding was continued.
hmm,
Whenever audit proceeding is continuing, this so-called notice should not be issued, or they have to wait till the completion of the final audit proceeding.
hmm.
Then only whatever the outcomes from the audit proceeding that will be initiated. They have not waited for that.
Hmm.
They immediately issue the
Under what,
ordinance.
what provision?
Under section 73.
What is to be, when you say that it is to be, they have to wait
Yes,
for,
we have intimated.
they have to wait for audit. Under
Yes,
what
yes,
provision?
I have intimated. My page number can be seen by.
No, it's not intimation. What is the provision that when the audit is going on?
Yes, yes. I
Audit
have
proceeding-
intimated them.
No, it's not a question of intimation. When the audit proceeding is on,
Yes.
no recovery, no notice can be given for recovery.
Yes, yes.
Under which provision?
Section 6. Section 6 of CGST Act, section 73 and section 50.
Show us.
65.
Show us.
Yes. There cannot be similar parallel proceeding by the authorized officers.
Hmm.
Section 6. Whereas the prejudice of the procedure provisions of this said the officers appointed under the state goods service tax or the
CGST.
this is central, and audit officers also central.
Hmm.
These both are same.
I'm asking CGST Act.
Yes. Sections authorized officer for the purpose subject to the such conditions of the state government shall be recommended of the council notify specified. Subject to the condition of the.
Sir, show us that when the audit is under process.
No, so ultimately audit was completed. There is no demand.
Hmm.
Audit has been dropped. My lord, page number, it can be seen.
Sir, I want to see,
Yes, sir.
show us a provision that when the audit is on, no parallel proceedings can be
Yes,
done.
yes, yes. But
Where
this
it is?
also-
Where it is? Where is the provision?
65, my lord, 65. Audit by tax authorities. Subsection 7, where the audit conducted under subsection 1 of the results of in details or detection of tax not paid or short paid or erroneously refunded or input tax credit wrongly evaded or utilized, the proper officer may initiate action under section 73 or 74
Hmm.
or 73(4)(a). So here,
No, this has already been, this 73 and 74 has already been initiated. An order in original has already been passed. So it's an appellable order.
no, my lord, during the continuation of the audit,
Hmm.
this order has been passed. So the superintendent should not pass this order
Hmm.
without waiting, before waiting of the audit proceedings.
Hmm.
In audit proceedings subsequently in 2024, when the total audit para was accepted by the appellant petitioner, so in that case, nothing remains.
Where it is?
Yes, ma'am.
Where is the acceptance?
Yes. Page starts 57.
Hmm.
57 GST ADT 02. In the last, your books of accounts has been accounts records for the period 2017-18 to 21-22 has been examined and audit report is prepared on the basis of the information available in document furnished by you and information so and so. And thereafter, in page 58, audit plan, non-payment of late fee, second, non-payment of interest and non-payment of GST on commission received repairing charges.
Hmm.
These has been has been accepted and closed by minute number so and so dated 28 to 24. Second,
Accepted an amount to be recovered
Yes.
in 30 days, else a sin to be shown. Yes, you have paid
Yes.
this.
yes, I have accepted and paid it. And thereafter, one para was remaining,
This is of which 5/3/2024. 5/3/2024.
my lord,
5/3/2024. First show cause notice was issued in 2022.
22.
Then
Yes. Audit para has been 24. During period 5 years audit was conducted. It took time by the department. Thereafter, this has audit para has been accepted. And at page number 64, my lord, can be seen. Page number 64, drop proceedings have been dropped. Please refer to the ADT 02 sent to you by this authority so and so. In this regard, I have been informed you that the headquarter have high detail number so and so. 18C24 has informed that the para number 3, non-payment of GST on commission repairing charges on this initiative referral, Mr. Gogoi has been closed and may be treated as settled.
where is the recovery? Recovery notice.
Notice, 55, page number. April 2026.
No, when this notice was issued, 7/4/2026, have you brought these facts?
Yes,
Where?
that
By,
has been, that
by
is
which?
at the time of the adjudicating officer before the superintendent,
Huh?
this matter was brought to the notice that since audit is continuing,
Not continuing.
Yes.
After the completion.
after not during the continuation, adjudication was conducted. Petitioner appeared in person, requested not to initiate any proceeding till completion of the audit proceeding.
Hmm.
But respondent number 5, the superintendent did not wait and is to confirm the demand of 16 lakhs.
Where it is? What is the confirmation of demand?
Page number 36. At page number 52, the order.
This is before the completion only.
Hello? Hello?
This confirmation was of 18/12/2023.
Yes.
Your audit was completed on
24.
24.
Started from 23 onwards.
Hmm.
It took near about 1 year
Hmm.
to complete the 5 years.
No, I'm saying after the completion audit, did you bring on record this completion of the audit?
That has been recorded. We have recorded on 18th July at page number 65. To withdraw the proceedings. We had intimated on 18th July, file AS 17 for withdrawal of the proceedings initiated.
Where it is? Page 60?
File. We have filed, but that is not considered till date.
Heard Mr.
Sahu, D. Sahu.
Disha, learned counsel for the petitioner. Challenge made is to the show cause notice dated 26/12/2022, comma, the original in order dated 18/12/23, as well as demand recovery. What is the last order of recovery? 07/04/2026,
Page 55.
passed by the respondent authorities of GST for recovery of rupees 16 lakhs 95,769. On leasing availment of excess input tax credit during the period from December 2017 to 2018. List of it is the case of the petitioner that there was a parallel proceedings as regard the demand and the parallel proceedings of demand and the audit list of the when the audit is under process, no action could have been initiated by the respondent authorities. List of be that as it may, the audit has been completed and the petitioner has accepted, which has been brought to the notice of the respondent authorities. However, by the impugn recovery of confirmed demand, and then by impugn reminder, by the impugn demand recovery notice that is 0704/2026 by a reminder, the respondent authorities has illegally directed the petitioner to the authorities is sought to recover rupees 16,976 on the basis of the order in original dated 18/12/23. List of next paragraph. Issue notice returnable by 4 weeks.
Yes, my lord. My lord, till then, some interim relief may.
What interim relief?
Because they may recover, attach the bank account because by this recovery notice. They have given me only 2 weeks time.
You are appearing. You are for?
For respondent number 1, madam.
Who is for this CGST? Have you not given the notice?
Yes, yes,
You furnished the notice?
yes.
Who is that? Who is appearing? Mr. Edatta Lanet, CJC enters appearance and accept notice on beverage program. Number 1. No formal notice need be issued as Mr. Next paragraph. Petitioners to take steps for service of notice upon respondent number 2, 3, 4, and 5.
Yes.
You furnish the copy.
Yes, sir. We will.
Next paragraph. Having considered that the audit in terms of section, having considered that in terms of section 65 of CGST Act 2017, the authorities have already completed the audit which has been accepted
Accepted.
by the petitioner. On when you have accepted, audit was completed on
For page number 64.
audit is
Audit
where?
accepted on 18 June 2024.
18 June 2024,
24.
Till the next date. No coercive action
Yes.
shall be taken against
Actually,
the
they have issued that.
petitioner. Ah.
No coercive action should be.
Huh?
No coercive action should be released.
List after 4 weeks.
Like.
Thanks.
Item 4.
May I please, my lord?
Yes.
This case, my lord, is son of the petitioner, my lord, was killed by the accused persons, my lord. And being the next of kin, my lord, he has applied for financial compensation, my lord, under the victim compensation scheme, my lord. In this case, my lord, he has submitted a representation, my lord, at page 33, my lord. And that is pending, my lord.
Huh?
That is pending, my lord.
Which one?
At page 33, my lord, she has submitted an application, my lord,
For what?
for victim compensation, my lord.
Yes, madam.
Notice may go, my lord.
Is she entitled or is he?
May kindly peruse paragraph 9 of the petition. Statement has been made that the application which he has forwarded to Asalsa has then duly been sent to the DLSA. And the DLSA has also started inquiry in the matter. So notice make go at this stage, we'll try and find out the status of the inquiry.
No, since you have done it, you wait for some time.
My lord,
Okay, of
application
it's
was submitted, my lord.
2024.
Yes, my lord. That
Will
is
issue
fine.
notice or you obtain instruction?
We can obtain instructions also, Your Honor. May kindly issue notice 4 weeks and then in the meanwhile, whatever is the instruction, we'll
Okay.
issue on it.
Heard, Mr.
W. Rahman.
W. Rahman.
Yes, sir.
Learned counsel for the petitioner. By filing this application, filing this petition, the petitioner claims for payment of compensation of rupees 5 lakhs under the victim compensation scheme.
Page
On
38.
account of the Alice kidnapping and murder of the son of the petitioner on 28/11/2021. This stuff. The petitioner has contended that that an application has been submitted on 05/12/2024 to the Assam State Legal Service Authority, Kamrup, within brackets, Gauhati, which has been forwarded to the District Legal Service Authority, Amingaon, Kamrup, which is still under inquiry. List of next para. Issue notice returnable by 4 weeks as MS M. Burman
Hardship.
for all.
No, my lord, for respondent number 1, 4, 5, and 6.
Which for finance? The constituents, huh? And MS R.C. Chaudhary, learned standing counsel. Legal Service Authority,
It's for 3 lordships.
district, whatever district,
Realistic, my lord,
huh?
5 I am appearing, my.
5 you are.
1, 4, 5,
respondent.
and 6 I am appearing.
6 also.
6 also.
And then enters appearance and accept notice on behalf of all the rest. No formal notice need be signed. Extra copies be furnished to the land council. List after 4 weeks. huh?
Obliged.
4 weeks.
4 weeks. Yes.
May I please, Lordship?
Yes.
So this matter relates to non-allowing of the registration of land sale deed by the authorities, Lordship. Both the petitioner, number 1, being seller and purchaser applied for NOC before the competent authority. And see, page 14 is the NOC for registration of deed, Lordship, land deed. Page 14.
Page 14.
Yes, Lordship. This page 14 is the NOC for land registration, Lordship, dated 23rd June 2024.
Ah,
No, Lordship. And this Lordship, kindly see serial number 3 in the last,
it
Lordship.
has been rejected.
No, Lordship. This is a permission, Lordship.
Huh?
Kindly see serial number 3 in the last,
What they have said.
Lordship. They are not allowing to the registration of our deed, Lordship, saying that there is a OM dated, Lordship. Kindly see the OM at page 32, Lordship. That is dated 6th of September 2024. They are saying, Lordship, temporary measures related to land sale and mutation in selected areas. In respect of.
Let us see. We'll issue notice.
Yes, sir.
Mr.
S.U. Ahmed. S.U. Ahmed.
S.U. Ahmed, named counsel for the petitioner. Next para. Agreed by the. You want NOC?
NOC I have obtained, Lordship. Now they are not allowing the execution of the deed, Lordship.
Why?
Lordship, there is a OM lordship
Hmm.
saying that there is a restriction in the district concern, but that is
That's a sick concern of what?
Barpeta
For
district
what?
for non allowing the rest new deed lordship. That is much later than my NOC lordship. My NOC was issued on 23rd of June 24, and this OM issued on
Petitioners, huh? Next para. The petitioner claims that the case of the petitioner is that the petitioner number one has agreed to purchase land from the petitioner number two, measuring 19 lesser by Miadi Patta number 182 and the dark number 907 at village Dangar Kuchi, Moja, Gilazari under Barpeta Revenue Circle, Barpeta, and obtain the NOC for NOC for permission to sell, which was issued on 23/06/2024. List of the on the basis of the NSC, the petitioners have applied for registration of the sale deed.
yes, lordship.
Sale deed. Just how about the state authorities have refused to allow the registration in view of the on the purported in view of the office memorandum that is 06/09/2024, which where it is
Page
page
32 lordship.
32. By which the new land sale permissions is banned. List of next paragraph. It is a contention of the petitioners that the petitioner has already obtained the NOC on 23/06/2024, and the aforesaid of and the office memorandum has come into effect from 6/09/2024. Therefore, please, therefore, the said office memorandum would not have a retrospective effect. Please, the next paragraph. Issue notice returnable by 4 weeks. You are appearing for both of you. P. Bora.
Yes,
P. Bora.
PR Mohan.
Oh, sorry, PR Mahanta. Standing Councillor, Revenue, and
2 5 and
all. No, there is no formulas, however, so and so. It's after 4 weeks.
public.
Item 6.
May it please your lordship.
Hmm.
Lordship, in this writ petition, lordship, a petitioner sought no objection certificate as well as Form 50 in respect of sale permission, lordship.
Hmm.
Lordship, the petitioner is the sole owner of a property measuring 1 biga 1 kota soil, sir,
Hmm.
located at village revenue village Forugaza in Dag number 1337, lordship. And she having 3 daughters and 2 sons. One of her daughter, namely Sontida's lordship, filed a civil suit being title suit 764/2022, which is pending before
Your
the
daughter?
yes, daughter.
Yes.
I am the mother of this case, Your Honor,
Okay.
lordship, which is pending before the civil judge, senior division 1, lordship. claiming right title interest over a limited portion of land measuring 2 kotha 10 lesa out of the total land measuring 1 bigha 1 kotha 6 lesa lordship. In connection with lordship, an interim injunction was granted to my daughter lordship. Subsequently, lordship, for which the petitioner approached the respondent authorities for providing her necessary permission or NOC for transfer of her land. However, the same was not granted due to objection raised by the said Sontidas. Being a brief lordship, CA preferred a writ petition before this honorable court. Thereafter, on lordship, 14/3/2024 lordship.
Any order is there?
Yes, lordship.
Where it is?
And except 6 lordship.
Any order refusing to issue NOC?
Yes, lordship. Thereafter, CS preferred a writ petition before this honorable.
It's all right, yeah, we'll consider what is this. Where is the, any order has been passed refusing to issue NOC?
That is page number, lordship, 86.
Ah,
86, last page, lordship.
86.
Yes, lordship. This is the Form 50 format, lordship. Where is my title suit 764/22? The said standard of Kamrup Metro denied.
I'm asking where it is?
Title suit 764/2022, Lord. CR.
Page 86.
Yes, lordship.
How do you know that this is an order?
No order, lordship. If there is any objection, they can put the case number behind the Form 50 application, lordship. And Form 50 application is at page number 85, lordship.
I will get the instructions, lordship. As because
Lordship,
title should
no, lordship. In the meanwhile, lordship, the honorable
Heard Mr.
D. Burman, lordship.
D. Burman, learned counsel for the petitioner, claimed to be aggrieved of refusal to issue NOC / Form 50 in respect of the land, what? Land measuring 1 bigha,
1 bigha 1 kotha 6 lesa, lordship.
1 kotha 6 leches, covered by dag number 1337 and patta number 712 of Revenue Village, Saru Sajai. This petition is instituted on the ground that
Lordship, kindly.
the title dispute in between her daughter and with her daughter pending before the civil court is not connected with the NOC, not connected with the is outside the land for which an NOC has been sought for. Next para.
Lordship,
Considering the matter, considering the issue involved, Mr. H. Sharma, learned state counsel, as well as PR Mohanta,
Lordship, if
learned
possible,
state
kindly.
standing the revenue directed to obtain instruction list after 2 weeks.
Lordship, kindly peruse the page number 73, lordship.
Yes. So
Page number 73, lordship. Wherein the learned civil judge already give permission to provide the all necessary.
that's why we want the instruction.
Yes, lord.
We'll see.
Kindly fix that, this, lordship.
Why you are in a hurry?
Lordship, this is because the petitioner is at the age of 85, lordship.
I understood. That's why 2 weeks. Give that.
Deeply obliged, lordship.
Item 7.
Yes.
Your lordship, the petitioner is a retired employee and he had to pick a fixed deposit account with the IndusInd Bank Ganeshguri branch. Actually, he had a total amount of 6,44,000 fixed in that bank.
Where it is? Where is the order? Are you challenging the order of the ombudsman?
Yes,
Where it is?
it's in page 48.
48. Yes. What does it say?
It states that I have downloaded one PM Yojana app due to which my phone was compromised and due to which all the OTPs were transferred to the scammers, Your Lordship. So they are not just accepting the negligence on the part of the bank. Actually, Your Lordship, on 23rd, when the transaction happened, we complained it to the bank itself. And also on 24th, we filed another complaint. Since 23rd was Sunday, we called the relationship manager and we informed about the incident, Your Lordship. Again, on 24th, we went to the bank and filed this complaint before the bank branch. Again, on 25th, we filed a complaint before the NCRP, and on 26th, again, we filed another written submission, written representation before the particular branch, Your Lordship. Then on 2/12/25, we filed another complaint before the Dispur police station. Till Your Lordship, 19/2/2025, we haven't got any reply from the bank. Later on, we filed one complaint before the ombudsman. Only after that, they have replied that.
Heard, Mr.
As
Relation
per-
notice, let us see. Who is for the bank? Anybody from the bank, for the bank?
For the respondent bank report. IDFC bank.
And what with the RBI?
Order number
You will have to take steps. Okay. Heard, Mr.
SK Rahmatullah.
SK?
Rahmatullah. Rahmatullah.
Rahmatullah. Learn counsel for the petitioner. Next para. By filing this petition, petitioner has put to challenge the order dated 20/02/2026 passed by the RBI Ombudsman. Page
Page 48. you know.
page 48.
Yes.
What does it say? Passed by the RBI Ombudsman. Respondent number 1. Hearing. Whereby the complaint of the petitioner regarding the your complaint is regarding what?
Premature liquidation of my fixed deposit and subsequently being fraudulently transferred to two different bank accounts of HDFC and IDFC.
Regarding premature liquidation of
Yes.
the fixed deposit of the petitioner. And the State Bank of India.
No, IndusInd Bank.
IndusInd
Bank.
IndusInd.
Bank.
IndusInd Bank. Which place?
Ganeshguri branch, Your Lordship.
Ganeshguri branch. And the subsequent what?
Fraudulent transfer, Your Lordship. Without my
Subsequent alleged fraudulent transfer of amount of rupees 16 lakhs,
6 lakhs 50.
6 lakhs, 50,
50,000.
50,000. This stuff. It is the case of the petitioner that the moment the petitioner was aware of the fraudulent transactions, same was reported to the concerned authorities for necessary action. However, no action was taken as required. Issue notice returnable by 4 weeks. 4 weeks. As Mr. You are for respondent number? You are
Yes.
Sarma?
Lordship, I am for 5 and 6.
Enters appearance
Big
and
shot.
accept notice on behalf of respondent number 4, 5 and 6. No formal notice.
4 by my learned friend, Lordship, 5 and
Yes.
6 myself.
Our extra copies be furnished to the land council, the respondent number 4, 5 and 6. Next para. Petitioners to take stage for service of notice of respondent 1, 2, 3. Registered for so and so, so and so. Within 3 working days. Yes. Next.
May I please your lordship?
Yes.
This is the matter in which lordship, the impugn order has been passed, lordship, by an authority who has no jurisdiction.
Hmm. Who is the authority having the jurisdiction?
Lordship, the assistant commissioner. The order has been passed by the superintendent.
Ah.
Lordship will kindly see it.
Why you are saying so?
Lordship, because there is a circular by the department itself.
Ah.
At page 218, if your lordship will kindly see
Can
page.
the jurisdiction be conferred by the circular,
Lordship,
not by the statute?
Lordship, the circular is binding on the department.
Yeah.
Binding on the department. The circular said that.
Under the
superintendent-
under the statute, who is the authority? Is the superintendent or the
It's an assistant commissioner.
assistant commissioner?
Assistant commissioner. Superintendent only by.
Then why circular is required?
Because lordship, circular has come into being to give the power and authority to the superintendent to adjudicate up to 10 lakhs.
Ah.
My amount is more than 10. Lordship, in fact, similar cases are already pending before this order court, and lordship, an interim order has already been granted.
So where is this? Where is the order?
Lordship,
Order challenge? Order put to challenge?
lordship, page 165.
165.
In fact, lordship, page.
This is by superintendent.
Superintendent, lordship will see at page 185, the signature is there by superintendent. Page 185, last page, the superintendent had signed the order. Superintendent Dubri range.
85.
85. Yes, your lordship. It's the superintendent Dubri range.
Hmm.
And lordship will find that in the circular, lordship. Page
Okay. We'll agree if you are saying so.
Yes, your lordship. Lordship. Page 218.
Subject to what he said.
Lordship, the similar cases are pending before this honorable court.
Where it is?
Similar. Lordship, I am given the orders copies.
Third, MS. Alia, huh?
Yes, your lordship.
And Alia, learn counsel for the petitioner. Challenge made is in his petition is to the order in original.
Yes, your lordship. Order in original dated
08 12 20 25 passed by the
Superintendent Dubri.
superintendent
Dubri range.
Dubri range GST
Yes, your lordship.
Dubri range GST
Yes, your lordship.
GST
Which has been confirmed by the order in appeal dated 13
and the confirmation order in appeal dated 1303
Yes, your lordship.
2020 is passed by whom?
Lordship, this is by additional commissioner. Respondent number 3.
Additional commissioner
Appeals.
within bracket appeals.
Yes, sir.
Bracket close. What is demanding? What do you call it? Levying a demand of, na?
Yes, your lordship.
Rupees 31
Yes, your lordship.
lakhs 48,488 on the petitioner on the ground that the superintendent within bracket superintendent
Dubri range.
has no jurisdiction. List of issue notice returnable by 4 weeks. You are appearing for all,
Yes, your lordship. He'll be appearing.
huh?
For 2 and 3, he will be appearing.
2 and 3. Three respondents only.
Yes, your lordship.
Okay. As Mr. A. Datta, learned CGC and Mr.
BN Gogoi.
B. N. Gogoi.
Yes,
You are standing counsel, no?
yes, Senior Study Council for Income Tax Department,
Senior standing counsel,
GST department.
GST.
GST. Enters appearance and accepts notice on behalf of all the respondents. No formal notice, they have extra copies, huh? Next minute. Considering that the superintendent, Dubri range appears to be not a competent authority in terms of the circular. The circular dated 09/02/2028, read with circular dated 27 and dated 27/10/2025, comma, till the returnable date, comma, no coercive action be taken against the petitioner. Yes. 13? 11, 13 and 15. You just take the date of the check. Item 11, 13 and 15. You just take it, huh? Take it from that one. Yes, sir.
Challenge can be ordered on state number 44 and 45. Whereby the executive will pass a blanket order without giving me the opportunity of being heard.
Of what? For what? Saying what?
The second round of review. First, after the finance department gave a standing order, he applied to the permission, but they denied us the permission, saying that they have not officially received the order of the finance department. It was out on 11th of November. We applied on 14th of November. Subsequently, we approached this honorable court, and the honorable court, after round of hearing, have passed that the basically fulfill the necessary criteria, our permission will be granted. Thereafter, your lordship, without giving us an opportunity of part, very abruptly on 6th of May, they deny our permission. It is very much within their purview. They can deny our
Permission for what?
permission for conducting a lucky drawing.
Not lucky though.
Lucky drawing. But it is the event of a festival. For lucky draw, coupon in date.
Is it not against the statute?
It is again scheduled that the Honorable High Court passed an order. After that order has been passed, the final.
Where is that order? Where is that order? Page.
Number 2,
Page.
page number 29. After the Honorable Gauhati High Court has passed an order in petition number 3090 of the 2024, dated 11th of November 2025, the Finance Department has given an SOP to which a lucky draw game can be conducted. An SOP kind of order. That these are the certain criteria which must be fulfilled.
Pass to set aside the difference so and so and recommended method to secretary, and therefore in continuation of departments and in compliance with order, the petition has been re-examined with the lotteries regulation don't need decide again for this but organized convention, but it does not require any legal requirement. Yes.
So after this order was published, 11th of November, after 3 days, on 14th of November, we applied for permission before the state commissioner, right, in the due manner in which it was prescribed. We applied for permission. Now,
What is your recognized local festivals? Festival?
Recognized local festival is Dol Jatra.
Dol Jatra.
In our application, which is in page number 32.
This is only talks about Dol Utsav.
We have also applied for that particular Utsav, Dol Utsav. In our application in page number 32.
It's not mandatory.
It's not mandatory.
It says permission may be granted.
Maybe. They agree with that. So accordingly,
On what ground you have been rejected? On what ground they have rejected?
They have not specified.
Huh?
They don't revanceable. They have not specified as the ground. On what ground they are rejected. However,
Heard, Mr. We'll see.
Lordship, no lordship, the grounds are there. Your lordship may kindly come to page 44.
Yes.
That is the ground rejecting their prayer. Firstly, may I draw your lordship's attention to annexure to page 29. that is the order of the Finance Department 11/11/2025. Has your lordship got it?
Page?
Page 29, annexure 2. That is the order just now, my lord.
Yes, yes.
That is 11/11. The lordship may kindly come to the fourth paragraph.
Hmm.
However, has your lordship? got it?
Yes, yes. Over the
Seven-
years, organized gift
Religious
coupons
committee have over the years
primarily for
organized-
community welfare
During-
and charitable.
This is important, lordship, this word, during festivals. During festivals such as Ras Mahotshav, so and so, so and so, so and so. Then last paragraph. Permission may be granted by the district commissioner for conduct of gift coupons, so and so, during recognized local festivals. The festivals was in the month of March. They have applied. So
Hmm.
this is not during the festival time.
Ah.
It has already gone by.
But 2 months prior.
It's
Then
okay.
lordships may kindly come
It's
to.
gone over now.
Equal litigation going on.
Huh?
One party.
But now,
No,
now there is
festival
no
is over
Dol
now.
Mahotshav.
Dol Jatra or Dol
It has
Utsav?
already gone.
Gone. Next, you try next.
Yes, then your lordships come to page 40, 44, annexure, that rejection order, annexure 10.
Ah.
They are selling the lucky coupons without there being a permission from the authority.
Ah.
So they are already there in a, they have already thought that they will get the permission. So accordingly, they have started selling the tickets. Second
Hmm.
paragraph.
Hmm.
Whereas it is seen that the organizing committee was involved in the activity of selling lucky draw tickets without prior approval from the district administration, Hosai, and when the
Where
matter
it
was,
is? Where you are reading?
that is page 44, annexure 10,
Huh.
second paragraph.
Hmm.
And whereas it is seen that the organizing committee was involved in the activity of selling lucky draw tickets without prior approval from the district administration, Hosai, and when the matter was sub judice before the Honorable Gauhati High Court.
Ah.
Then lordships, fourth paragraph. And whereas several public complaints have been received by the office of the district commissioner Hosai alleging illegal selling of lucky draw tickets without prior approval by the district administration Hosai. Then next paragraph. And whereas abiding by the court order and based on the public complaint petitions, a joint inquiry is conducted by the co-district commissioner Lamding and a co-district superintendent of police Lamding, as per inquiry report submitted by the co-district commissioner Lamding, white number so and so, dated so and the report submitted by the co-district superintendent of
It's okay. We'll issue notice. That's all. Heard, mister?
Yellow.
Huh?
Yellow.
T.L. Laskar, London Council for the petitioner. The petitioner. What is this? What is it? Who are you?
Number Sikalabari,
What is it?
registered on the page number 20 in the registration.
No, it's okay. What is you? Who are you?
Thank you.
A society, namely 2 number Sitlabari Sarvajanin Shiv Mandir Parichalana Committee, represented by one Sri Mantu Devnath, challenges the order dated 06/05/2026 passed by the Additional District Magistrate.
yes, lordship. Hosai, lordship.
Whereby the
And because of this lordship, one
application
criminal case is also pending.
application for permission to conduct lucky draw
Yes,
within bracket lottery ticket lottery has been rejected. List of issue notice and for in respect of what festival of what in for
Dol Jatra.
Dol-
And lordship, one of the
for
petitioners
for Dol Jatra. List of issue notice return over 4 weeks as Mr.
one caveat is here.
Well, just wait. So and so, so and so. You are representing all,
No, lordship, 1, 3, 4, and 5.
and then rest
Rest, lordship.
finance. And you are
One caveat is there, but caveat is not pressed. I have it started.
okay. No formal notice need be served. Anybody who is unrepresented?
Lordship, all are
All are
represented.
represented.
All are represented.
You are not pressing the caveat. This stuff. Extra copy, so 4 weeks.
Lordship.
Mr. In caveat, where is the caveat? Caveat stand disposed of, not or not being pressed.
Not correct.
Item 10.
Yes.
part of the process. One person recorded her. It will treat effort to the precaution. Also, may kind of see page number 13. And approaching the police registered a case at number 6. They have not done anything. Thereafter, I have approached the SP law. That was not have been done. That
You obtain instruction, what's there?
There is an alternative remedy, my lord. If police and superintendent is not
That he had,
acting,
huh?
my lord, they can file an application before the CGM, my lord.
SP law.
Yes.
No, that is there.
First, my lord, if the
That was motion by 96 page number 21. That was also forwarded to the PSO. But within that, nothing is been done option. I'm a lady on people. We are enforcing the person also. At least as a problem is that the person.
Heard MS S Kanun. Kanun go, then counsel for the petitioner. Next para. The petitioner is claimed to be aggrieved of inaction on the part of the respondent authorities in registering the FIR filed by the petitioner against one Siri Liwakot Ali Ahmed. List of the petitioner pressed for a direction to the respondent authorities to register her FIR dated
At page number 13 onward.
not onwards, FIR dated. But you can mention your FIR. Where is the date? Where is the date? It appears to be a little bit, you yourself appears to be a fraud. Not Likat Ahmed. Before the officer in charge, Badarpur Police Station, Badarpur, Assam, and the superintendent of police, Sri Bhumi. Issue notice returnable by 4 weeks. You are appearing for all,
all, my lord.
as Mr. N.C. Das.
No, 1, 2, 3, 4, 5.
So it appears for
1, 2, 3, 4,
1, 2, 3, 4. 3, 4, and 5.
Till 5, my lord.
No 4 minutes. How about accident? MS Angel and consent for the petitioners to take his test for service and notice upon respond number 6 within 3 working days.
Extra copies, my lord.
Yes, excellent.
Item 12.
Huh?
Issues regarding was received and 2022. And one of that body was covered and it was in the condition that passing modified. And subsequently one missing report was filed. Again, number number 23. Subsequently, concerned police station. In certain case, we are case in the case number 12/22.
categorize the case as undetermined case. But time to balance the postmortem report. Page 30.
By, they heard Mr.
Yes, sir.
Learned counsel for the petitioner. Next para. By this petition, come on, the petitioner is seeking for transfer of DDR PSUD case number 12 of 2022, dated 23/11/23, within bracket DD number 12 of 2022, bracket on page 10, here person, to the crime investigation department or any other investigating agency. To ensure a free, fair and impartial investigation on the death of his brother,
Yes, hello.
elder brother, namely late.
Chandra
Huh?
Das.
Where do we get it?
It's there in the pleadings.
Huh?
It's there in the pleadings.
Where is it? Where is it? Just would like to know.
Page 5, sir.
Ah,
5 is also there, madam. Late Sushananda went to his niece house located at Matiala. Good know.
where do you get it?
Page
Name,
5, sir.
name of the deceased? Ah,
Page 5, later part of the kind of more, sir. Going to clear at home, one day before.
Susendra Das. Huh? List of. You obtain instruction and what do we do? What is the investigation will say? How far it has gone?
Status of the investigation.
Will issue notice or you'll just obtain the instruction? Huh? Issue notice returned by 4 weeks. 4 weeks. As Mr. What is your name? NC Das.
And thus,
And thus, Land Council, State Council enters appearance, accept notice on behalf all the respondents.
all fine.
No formal notice, have extra copies of furnished.
Extra
And if we had notice, extra copies,
extra copies to do.
14, item 14.
what is the issue? With your senior.
At 2, my lord.
Why? Will issue notice? Will issue notice?
Only.
Where is this here? Will 5 minutes. Will resume after 5 minutes.
54 supplementary list.
We are having Yadi Pata land of this.
So contempt, will issue notice. What is the order?
The 103 logic, the given page.
Heard Mr. So-and-so London Council for the petitioner. This is an application under section 12 of the Contempt of Court Act 3 with Article 215 of the Constitution of India and the High Court Rules 1977. Alleging willful and deliberate violation of the order dated 27/03/2026 and 24/04/20 passed in WPC 187 of 2026. Next by issue notice returned by 4 weeks. Learned counsel for the petitioner. How can we do say that? It's a contempt petition. Is it not a contempt petition? It's very strange prayer. How many respondents?
Yeah, one.
Ah,
One.
barrister for so and so.
Okay.
Well, you take the steps within 3 days.
Okay.
Yes. Ah. Ah. Hmm? By whom? Heard by whom? Huh? Heard Mr. R.S. Mr. Learned counsel for the petitioner. Challenge made next is the demand so called notice. What is this? Challenge made in this petition is to the order in original dated 29/12/2025, confirming the demand of rupees 7,21,64,532 towards the tax with applicable interest and penalty for the year by claiming multiple financial year I 2018-19 to -19 to 22-23 on the ground that same violates the provision of section 74 of GST Act 2017. Issue notice returnable by 4 weeks. You are appearing for all.
Lordship, 2 to 4. 2 to 5 I am appearing.
You take a steps for one. Huh? But he's not today. He's not there. You should. Huh? Jain.
Lordship.
K. Jain, learned counsel appearing on behalf of Mr. S.C.K.
Lordship.
Learned standing from the GST. Enters appearance action noted on the restaurant 1, 2, 3, 4, and 5. No formal notice to ensure. Extra copies we furnish. Mr. Aristu, huh? We don't know. Considering the similar in a similar matter, an interim was according the till returnable that no perceived action shall be taken against the petitioner. Same. Same of what? Same. Order is same. Order in original, huh? 10/10/2025. Amount is 158,64,297. The financial year is 2017, 2018 to 2019 to 2020. Same. Yes, Mr. Gogoi.
whether, whereby the time for passing order under section 73(1) has been extended for another 3 years. The lordship will find that page 46, or to make it easy. 46. Here, my lord, Roman 1, my lord. For the financial year 17 and 18, it has been increased to 31st of December 2020. Whereas, my lord, it will have to be, my lord, concluded by within 3 years of the due date of submission of return of any financial year. So that will be, my lord, 2021. Now it has been enhanced to, my lord, 2023.
Pursuant to this, they have
They have issued a demand notice also, my lord, order has been passed. Now, my lord, this is pending for the Honorable Supreme Court. The series of cases there of before the Honorable Court also. So I blame, my lord, constitution of the, my lord, the means that, my lord, no coercive action. That's it.
and Mr. B. Gogoi, learned counsel or additional? No, learned counsel for the petitioner. Next para. Challenge is to the obligated. The challenge, the petitioner challenges the notification dated 31/03/2023 was by the director of what? Director, Ministry of
Finance.
Director, Ministry of Finance, within bracket Department of Revenue, Central Board of Indirect Taxes and Customs, Government of India. Whereby the time limit specified under section 10 of section 73 of Income Tax Act,
No, Lordship, CGST.
CGST 2017
Lordship.
for issuance of order under subsection 7 of section 72 said act is extended on the ground that, what is your ground? Why are you challenging it?
My lord, this particular notification has been issued under, my lord, section 168A, under the provision force majeure. Force majeure, my lord, it was issued initially for the, my lord, purpose of COVID, my lord, 19. It has, my lord, expired in, my lord, almost in 2021. Subsequent to that, it has been enhanced in, my lord, 2024.
On the ground that no extension could have been granted under section 168A of the said act as the at least as the force measure was no longer there. Huh?
Yes.
What do you call it? Force measure of what?
So that
The-
is
the-
specific term.
The reason for force measure.
Yes, it is the reason for force majeure.
Where is there was no force measure at the relevant point of time. Well, I'll just find out what is this. The petitioner also challenges the consequential order of.
Then page number 3.
You just tell us consequential order. Consequential order in original.
Yes. 7/12/2023 and
Dated 11/12/2023
2023 and order in the appeal dated 13/12/2024.
and
Page 50.
and ordered in appeal.
Order in appeal.
Order in appeal dated
13/12/2023.
13/12. Oh, this is something. Page
Page 56.
56 is original in the order.
So that is the
Appealable order.
original order is the page
50.
50. 50.
12/12/2023. No,
11.
11/12/23 and then
And then
order in appeal
13/12/24 at page
56.
after the letter and
Whereby a demand of rupees
lordship find that the-
1,30,14,036. That is page 78, Lordship. Roman number. 1,30,14,036.
Confirming the demand of and the confirming the demand of GST amounting to rupees 1,30,14,036 from the petition for the financial year 2017 to 18. And along with interest and penalties. List. Issue notice returnable by 4 weeks. You are appearing for
Lordship, for 227.
Borua.
Yes, sir.
Sorry, MSB Sharma and Mr. So K. Jain.
Lordship.
It's
For
appearing for
227.
Standing Council. Appearing for Mr. S.C. KL, then Standing Council for GST and CGST. GST, just CGST.
CGST.
Does appearance accept notice on behalf of this, so no formal notice to be served by extra office. We permit to the land council to the respondents. Then what is your interim prayer?
For day of this, the possible say no coercion in the meantime.
Considering the submissions of land council for the parties and also no. And also considering the issues. No, the similar matter is pending before the
Lordship.
pending before the Honorable
Lordship, before the
Supreme Court,
division bench and before the Supreme Court also.
as well as before the division bench of this court, till returnable that no coercive action shall be taken against the petitioner. Then
The other case, here notification is 56 of 2023. And the financial year will be 19 and 20.
notification is
Page
page
100.
100. Yes.
By the same
28/12/2023. Page 100. Notification is 28/12/2023. Same.
The number 56 of 2012.
Page 100. You give that other numbers. And
The order is at page 102.
102.
Yes. 26/8/24.
Original
Yes, sir.
26/8/2024. And
But this is the last one.
okay. You have not filed an appeal.
But, in the meantime, that Honorable Supreme Court has already issued notice on the other. In February 2025.
And for
Here
amount,
the order will be,
amount is
yes, sir. The amount will be, madam. The document find it at page 111. 37,000 or 37 lakh 19,716.
along with the penalty and interest.
Penalty and interest will be separate by law. It will be calculated of this particular amount.
Okay. It has not been.
No.
Okay, then only amount, no penalty and interest, right?
Along with penalty.
Along with penalty and interest, that will be calculated.
Along with penalty and interest. Assistant Commissioner, huh? Yeah. Passed by Assistant Commissioner, 26/8/2024. We start from page 102 at 112.
One of the financial year will be 2019 and 20.
19 and 20.
Problem.
Same.
Much of that.
Yes,
Well, the AG is in lakes in some other court, so.
when we should take it up?
Proper time being.
After 2 only. Timing, huh? Timing. It's a pattern method. We'll have to take it up.
Wait, please, Your Lordship.
Hmm.
My lord, my senior is now appearing in another court, so I'm humbly praying for a time being.
Hmm?
Humbly praying for a time being as my senior is appearing in another. court.
What is the matter about? Huh? Of, this is for what? Huh?
So they have got some,
What do you want, sir? What do you want?
I have some money, the 2 year, financial 2 years, the amount of due loss.
On account of what?
And
For what?
halfway home.
It appears to be Ben's matter, man.
Huh?
It appears to be Ben's matter.
This before, I know it is submitted by Mr. You are claiming for payment of outstanding bill. Outstanding bill. It is submitted. It matter pertains to civil bench for Mr. Rested to verify and list accordingly before the appropriate bench. Next. Now, if it is pertains to bench for, take it up. Huh?
That is, correct, Lordship, that's for matter.
Huh. Yeah. Do you agree that it's a bench for matter? Do you agree that it's a bench for matter?
And it's a that's for matter.
So,
That time paper and that date, that is that question.
not possible. Sorry.
Much of. I think.
Yes.
We directed to take instruction in this case, my dear.
Hmm.
We have received the instruction.
Hmm.
We may permit to file our affidavit.
What is your instruction?
Instruction is that he himself
Huh.
has surrendered his card
Hmm.
in the 2016 itself.
Hmm.
And thereafter, after this institution of this case, my lord, and an inquiry was conducted
Hmm.
by two, my lord. Area officer who deals in supply, and he had submitted the inquiry report. Lordship, have a look at this. Yes. No, give it to that.
Yes.
But
It's a long instruction or what?
no, I have given copy of it. Other part.
This is, you have translated.
No, I have just.
What is this?
Last page, your lordship.
What is this?
This is Asmi's, it is only instruction, I'll have to translate. So I paid for.
No relevant. No relevancy.
These are relevant. These are.
It is not relevant.
By way of affidavit, we'll be filing.
What is this?
We'll be translating and
What
filing.
what does it indicates?
Uh,
What does it say?
It says, my lord, he had surrendered the license.
Report regarding allegation of retention of ration card by.
Last page, your lordship. It's-
Huh?
Last page, your lordship. Okay.
Contains.
Last page of this.
Lordship
Lordship.
government reporting that harassment can have been taken back by Mr. Bangmal Bansal, proprietor MS Cemeteries. An inquiry was conducted by and yes, found this registered surrender the ration card bearing number to the press of LR and had submitted written surrender letter undertaking attached to the document.
Surrendered lordship, 2016. But,
Yes. Your husband has surrendered it. Is he still there? Husband is there.
The initial one before the National Food Security Act, the PPH card, PHH card, priority household card was issued to her. It was in the name of the husband. Then under the NFSA, it's issued in her name.
Where it is?
Under the priority household card, is issued in her name. She has never surrendered. And my allegation is that even before the legal addressal officer, we have raised that our ration card was being kept by the fair price shop owner, lordship, which is respondent number 7, lordship. And in our petition, we have taken our stand is that he has kept our ration card because under the NFSA, it cannot be issued in the name of a male person. It can be issued in the name of a female person. Under the NFSA. Ration card under the NFSA lordship is issued in the name of a.
What is your ration card number? What is your ration card number? Number?
That was not with us because the card is being taken by respondent number 7. We have made our stand in this petition. He has taken each and even before the event addressal officer, we have raised this issue.
There was an inquiry. Inquiry is conducted. And it is found that your husband has surrendered the card.
Initial card which was issued, that was in the name of the husband. That surrendered and the new ration card was issued to her.
Where it is?
That is being kept by respondent number.
How do you know inquiry was made? Inquiry has caused and it was found that your husband has surrendered the card. That's why, unless you saw that this was my ration card, which has been kept by respondent number 7. But an inquiry was caused and it was found that your husband had.
My husband has never surrendered my ration card. My ration card is issued in my name.
Of the records, are you in good terms with your husband? Then?
We are saying together.
Wait, where you have not, there's no whisper regarding the surrender of the ration card by your husband.
The initial ration card which was issued before the NFSA.
So you know that you admit that his ration card was surrendered.
That is his ration card.
Are you admitting that has been surrendered? Have you said so? Heard Mr. MSD Ghost, London Council for the Petitioner. In terms of the order dated 21/05/2026, Mr. B. Talukdar, London Senior Council for the State, when the State Council submits, submits that he has received the instruction to which he would like to bring on record by an affidavit. Therefore, phrase for listing of the matter after 2 weeks. Phrase allowed. The list the matter after 2 weeks. In the meantime, the Mr. Talukdar to bring on record the instruction
Lordship, in paragraph 2, I have stated.
by way of an affidavit.
So, issued sometime in the year 1998, and with that ration card, the family of the petitioner was continuously receiving the ration. Thereafter, the government of Assam identified the petitioner as an eligible for the household and the household under the NFSA. The eligible and identified the priority household under the NFSA threshold. So the old ration card was taken of 1998, and thereafter the new ration card was issued in the name of the petitioner.
Who is for respondent number 7? Respondent number 7, anybody?
Earlier they appeared, and on the last petition they did appear, Lordship, and it's reflected in the order.
After 2 weeks. You just, huh? Let them file. You return this copy. Instruction return to him.
It pleases your lordship. Lordship, it's been since 2 years, the amended cost title has not been submitted.
Huh?
Since last 2 years, the amended cost title has not been submitted by the petitioners.
Infrastructure. Mr. Y.N. Mahanta appearing on behalf of S. Chomolan Council for the petition submitted. The date petition has become in process. Miss, you record all their name. All of you are appearing. Yes. Are present, huh? Accordingly, date petition stands closed as in process. Yes.
English.
Is it inconvenient? Should I tell the name? Is it names? You just for a time being you take their names. Who appears for whom, huh? Then I will next. Yes.
Passing order is
Mm.
if the state is still standing. Next look on the
This is also on force measure. Force measure. Okay. So what should we do? MS G. Saha, B. Sharma, Land Council for the petition submitted. The similar matter is being, similar issues are being examined by the Honorable Supreme Court. Supreme Court. Come on. Therefore, matter may be deferred. Just in view of let this matter be listed after 4 weeks. 4 weeks, interim order first earlier shall continue. 22 and 23. Yes. Huh? Same order. Same order. Interim, huh? Continue the interim. Yes.
If, regarding office, you can, that it were, the chief,
Any response by the state? Who is the main respondent?
I am appearing.
State.
Can it be taken after a week, my lord? He misplaced our record, my lord.
You have not filed affidavit, anything.
Affidavit is also is on the record.
Or Mr.
you will have.
A. Wahab, learned counsel for the A. Wahab. Spelling?
WAAC.
A-
WAACAB.
Learned counsel for the petition. On the prayer of Mr. N.C. Das.
And thus,
And thus, learned counsel, state counsel, as well as MS. R. MS R. N. Bordon, learned standing counsel, revenue department.
my lord,
Further-
since affidavit is also is not on the record,
Further-
we have not filed it, my lord.
Further 3 weeks time is granted to file affidavit in opposition.
But if they will be,
Either way.
4 weeks, after give 4 weeks in there.
4 weeks. After vacation,
No, in that case, just before the vacation, you just 26.
last day.
Again, 28.
Lordship, in this case, I am for the respondent and as per the order of this honorable court, I have submitted my affidavit on the last stage.
Additional affidavit.
Additional affidavit wherein we have stated that we are agreeing to refund the amount. Because what happened, Lordship, in this case, the petitioner before your Lordship participated in an e-auction conducted by the bank. Now, in the process of e-auction, he was the successful bidder and he deposited some money. Now it was entire money. I'm not disputing. That is not disputed fact. Now the bank resorted to deliver the position. Bank had from time and again taken permission from the deputy commissioner, but due to non-cooperation of the state officials, the position could not be given. Subsequently, there was a civil litigation, and due to civil litigation, the position could not be given. Now, this honorable court directed us that at what interest we could refund the money. Now the question comes for refund of the money. Now,
So you are not pressing for no, you are not pressing for the delivery of possession. Now you want the
Now, when you look at the records, the system will find that in 2017, the suit was filed, and they had the information in 2019 itself. But they suppressed the information, they never.
And then issued the e-auction.
23.
Okay.
Now we deposited, then they could not give handover also.
Lordship, the question of civil suit.
Now how much you want? You have deposited 90 lakhs. And then what is your seeking interest? 12%.
Lordship,
Yes, that's right. 12%. Then
18%.
Lordship, my lord will take my
you
additional-
tell us how much
the prevalent
90, 10 you have to, this is a principal amount. What interest you would like to pay?
The prevalent
20%,
housing loan
25%?
rate of interest is 7.25. Even if you take housing loan and in the fixed deposit is 6.25.
We are not concerned. You know that the matter is the land is or whatever.
Yes.
It's a land only. The property is
Lordship, then I'll take my lord in similar sort of situation what the Honorable Madras High Court or Kerala High Court gave decision.
we are not persuaded.
My lord,
How much? They are not pressing that delivery.
Yes,
Amount
No.
you have to pay, how many years? When it was?
2 years, 2 years. 7.25 lordship, the highest rate of interest.
Supreme Court has given -18%.
No, no, no. The honorable high courts have given in 9% interest.
You are agreeable to for 7%.
7.25, there is a housing loan interest.
We're providing you 13%.
Lordship, that will be too much high.
13.
No, no,
13.
no. Lordship will just see that there is no fault in the part of the bank. What my learned friend is saying.
It's a fault.
What-
You
what
know
my
that
learned friend is suggesting that the bank has consulted
property is a subject matter of the title suit somewhere pending in the court.
Yes. There was
Jurisdiction
injunction
civil
from the title
court.
suit. There was no injunction from the title suit.
Doesn't matter.
There
Doesn't
is no
matter.
injunction as
Then why did you deliver?
Lordship, we
You have
have
accepted
taken-
the
we have-
money. You
we
have
have
made them the
taken-
deposit.
My lord will take my affidavit in opposition. We have taken permission from the deputy commissioner to deliver the position. And
Then
I have annexed. It is problem.
then why you have not
it
then
is-
why you have not delivered?
Yes, that is the thing. I've stated in my affidavit.
Why you have not delivered? When you have taken the permission from the deputy commissioner?
It is on page 53. Lordship will just peruse for a moment.
Huh.
Whether it is in page 53 of my affidavit in opposition.
53.
Yes, first. It is not that the bank is not. When did the order of the civil court came? Civil court orders came in the year 2024. This is the order of the deputy commissioner. For delivered, just.
No, we're not concerned now. Only
Thereafter,
we're
again,
concerned.
order was
Let
the-
us see your
the
affidavit.
The circuit officer.
Interest home loan at present 7.25 difference so and so amidst honorable Karnataka High Court in line so and so. What does it mean? Tell when the income is probably not disclosed the bank in the sale, not this sale notice was not directed to refund the earnest money with. This is not the earnest money. This is the earnest money.
No.
Entire amount.
Yes.
Can we pay the phase of 50 of the reissue? Once, or once.
It's okay. There's no dispute as regard the principal amount.
No.
13,
We are not disputing.
13%
Lordship.
till recovery.
Lordship.
From the date of deposit
No,
and
Lordship, my humble submission.
from the date of
9%. My humble submission, 9%. Your lordship may
And-
record my submission.
from the date of the when
Enter auction.
From the date of deposit.
from the date of the till realization 13%.
No, Lordship, can it be 12%?
Huh?
12%. 1%.
Yes.
1%.
Yes. Not 12%.
12%. Yes.
12%.
Yes.
Then that will be a consent order.
Yes.
Okay. Consent order 12%.
Yeah.
Let us not. I always this court is always believe in the settlement.
Yes.
Not only settlement, amicable settlement.
No.
That is the shortest way to that's the shortest way to resolve the issue.
Commercial transaction, Lordship, that commercial.
Therefore, 12%. Agreed.
12%.
Huh?
No.
Huh?
No.
I will not say anything. 12%.
It is not
From the date of deposit to till the realize till release till final payment.
Till final payment.
Till final payment. Heard Mr.
Deposited on 6/5/23.
We'll
We will see. That is in our record.
I'm not learned senior counsel assisted by Mr. DJ Kapil, learned counsel for the petitioner. And also heard Mr.
KK
Please.
Nandi, Lordship.
A.K.
Nandi.
Nandi, learned standing counsel,
No, panel advocate.
learned counsel for respondent number. All the respondents,
All that. 2 and 3, Lordship.
2 and 3. Who is one? State Bank of India,
Yes, one also. Yes, same.
1, 2,
1, 2, and 3.
1, 2, 3. Who is 4? Huh?
Original Barwa.
No.
Yes, but I don't know.
Okay. Non-APS service has been served. No, notice has been served.
On the other day, he was absent. He was present.
Non-APS
On the
for
other day, he was present.
the respondent for dispersed service of notice. Disposed of. We'll say the kind agreed and consent 12%.
may not be concerned, Lordship, because it will.
No, I'll say that. Then we'll say that initially you have submitted that it should be 12%, 7.5%.
7.5%.
However, ultimately agreed for 12%. They will say that. Will not say consent. You have fairly agreed for 12%.
No, if it is.
Otherwise, the court
No,
is
no,
inclined to impose
Lordship,
13%.
That's not 50%.
It's a,
No, Lordship may pass order for 12%, but it is not my concern. That it will be your Lordship knows.
then why you have agreed?
No, just I am sorry.
He will might eat the fish. He will not touch the water, my God. Something like, he will not touch the water, eat the fish.
No, I'll say that. Initially, you have submitted, you have agreed, you have
What,
submitted for
7.5%?
7.5%, but ultimately
Agreed to.
agreed to. All right.
And a big large-hearted platform.
Yeah. Okay. Next. Disposed of. This will- I'll pass in the chamber.
Item 29 and 30.
This case, my lord, for item 29, we will file affidavit today, my lord. We have received the signed copy. For item 30, in 2 weeks, we will file it, my lord.
Heard, Mr. Learned counsel for the petitioner. Next para. Petitioners. Different petitioners. Petitioners, huh? Mr. Next para, Mr. Bortakur. Learned counsel for the
Forest Department.
S. Bortakur.
I voted.
Sorry, I Bortakur, learned standing counsel for his diplomat submits that counter affidavit in WPC 6128.
No, 1080, my lord.
You have already filed.
Today it will be filed, my lord.
They submits that the counter affidavit would be filed during the course of the day in WPC 1080 of 2026.
And for respondent number 7 in 108.
And please stuff, he phrased for further 2 weeks time to file affidavit in WPC 6128 of 2025. Next para. Prayer, the prayer for prayer for adjournment is accepted. Comma. Mr. Escape for the council for respondent number 7 in WPC 108 of 2020 is present. List after 2 weeks. Then you raise. You are also praying for. Okay. Then you write, Mr. MS M. Burma. You are also appearing. A. Bhattacharjee, standing counsel for revenue department for respondent and M. Burman for 1, 3, and 4, as well as Mr.
For 7.
SK Podda for respondent number 7 are present. That's all. Huh? List these matters after 2 weeks. Accordingly. What is your prayer? Not 17, thereafter. Make it 22nd.
22nd. Yes.
Item 31.
Well, in this case, well, this is a case wherein the passport applications of the petitioners were rejected on the ground that FIRs are pending against them. Now, well, it is true that FIRs are pending against petitioner number 1, but no cognizance has been taken by any of the courts. Therefore, that cannot be a ground for rejection of passport. Moreover, my lords, there is no criminal case pending against, not even an FIR pending against petitioner number 2. Her passport has been rejected just because of the fact that she is wife to petitioner number 1, my lords. Now they required this passport for their Hajj pilgrimage, my lords, and because of the rejection, they could not avail the benefit of the Hajj pilgrimage on 25-26. Now, the applications have opened for the next year. Therefore, there is certain urgency, and it is also an admitted position that no court has taken cognizance of any of the FIR because no charge sheet has been filed. And in fact,
against whom?
petitioner number 1,
Okay. The passport is not been renewed for against whom?
No, it has not been issued, The applications themselves have been
Fresh-
rejected for
fresh-
both.
Okay.
Yes, both. And petitioner number 2, there's nothing against her. Just that she's wife to petitioner number 1, it has been rejected. The police verification report is also annexed.
My lord, I'm appearing for respondent number 3 and 4, your lordship.
Which respondent number 3?
Respondent number 3 is the state of Manipur, and the respondent number 4 is the officer in charge, police station.
Yes.
My lord, yesterday I filed the affidavit of opposition for respondent number 3. And only some more time may be required for filing for respondent number 5. I have to get
Respondent number 4 only.
respondent number 4.
No, it's there. But then who is the authority? Passport authority?
No, passport. I'm not the passport authority.
I am the passport authority.
Huh?
I am representing the passport authority.
Yes.
No, my lord, our stand is very
You are the one who has received.
No, we can renew the passport.
It's not renewal. It's a fresh passport.
Yes,
Yes, my lord.
Tatkal
Because
passport.
the issuance of the first fresh passport is also concerned.
Huh.
That is subject to the police verification report. My lord,
So why don't you file an affidavit?
My lord, we
I
have
filed.
already filed our affidavit.
Okay. So what to do?
My lord,
When is the pilgrimage? Hajj?
It
It's
is
over.
undertaken.
This year it's
No.
over.
25, 26, it's over. 26, 27, the applications have opened, but they're about to close, because it is undertaken by the Union Ministry. It is a sanctioned
Okay,
exercise.
26, 27, it's enough time.
No, the applications will be closed.
You have missed the 25, 26.
I
When
understand.
do you want? We'll dispose it when you can file the affidavit.
Within 2 weeks time. Because it
Well,
has
2
to
weeks
send
would be a
from the
little
authority.
long, because the application window will
2 weeks, any
close.
day.
To make it 10 days. We'll
10
fix
days.
that. It's a matter of passport, right?
Yes.
All right.
Because the affidavit will be coming from Manipur.
Is it?
But-
How far it is? How far Manipur
And
is?
your lordship knows the state government how they works.
It's
but
a police
enough
police
time have-
officer.
Yes.
Enough
Right.
time has already been granted, my lord.
My daughter is in Imphal.
Yes.
That's why I'm asking how far it is. How far the Imphal, Manipur is?
Yes, oblige. Your lordship, whatever your lordship.
Not
is.
even 1 hour.
Any day.
That too, you have this AI nowadays.
Yes.
Not
I will-
only
I will make
technology,
it
AI is there. 10 days.
Yes. I can, or I'll make.
And Mr.
A. Sahu, my lord.
Yes, Sahul and counsel for the petitioner. Next para, affidavit in respect of respondent affidavits, contrary affidavit in respect of respondent number 1,
My lord, I am B Dekamai.
1 and 2.
1 and 3.
You are appearing.
1 and 2, my lord.
1, 2 and 3
My lord, I'm for
have
three and
already been filed. Mr.
B Dekamai.
B. Deka, learned counsel for respondent 1 and 2 is present. Mr. A. annexing learned counsel appearing for respondent 2 and 3. 3 and 4 submits that he may be granted 10 days time to file affidavit on behalf of respondent number 4. Mr. Praise the Lord. List the matter after 10 days as the matter pertains to issuance of passport next to the petition.
Right.
My lord, a date may kindly be given, my lord.
After 10 days, you give it. We'll take care.
Grateful.
15 June.
Item 32.
My lord, during the course of the day, we are going to file our affidavit.
And Mr. K.U. Ahmad. Mr. H. Das, learned counsel for the petition. It is submitted by Mr. N. Das, learned state counsel that an affidavit in opposition shall be filed during the course of the day. Mr. Considering above, let this matter be listed after 2 weeks. 26, 22nd. Okay.
Item 33.
Allowing mutation. And exactly similar matter of by honorable Mr. Justice. Another court my lord discussed the matter by restoring the appeal.
Where it is?
We had filed our.
Same area.
No, my lord, yeah. We have filed our affidavit, my lord. Page 35, paragraph 4, my lord. That with regard to the statements made in the para 6 and 9 of the petition, the deponent beg to state that the applicant applied file number this for mutation in the favor of her by the deed register without NOC, land sale permission of the district magistrate Barpeta. As per principle stated in the section 21A laid down of the Registration Assam Amendment Act, the deed register of agriculture land without NOC is restricted by the government, my lord. And the mentioned land is agriculture class 4. Therefore, the mutation was cancelled by the circle officer.
But then he said something. Elijah Khatun. Huh? 2 bighas 4 khatas. Here. Dag number same. Dag number same. Then. Huh? He's in this petition, he's Elijah Khatun. You are?
I am here, my lord, Saniara Begum.
You have purchased from whom?
Purchased from them, seller, my lord, that is Ranibala Boshar. Page 18, my lord.
ये पहले ने appeal.
Yes, ma'am.
Huh?
Photo is scale. Photo is escalated. By the hospital. This photo then there is a appeal.
So that has been rejected.
That is why in the earlier case of exactly similar. You had situated and auto appealed automatically auto escalated.
Otherwise, also this is an appealable order under the Assam Right to Public Service Act.
No, he has filed an appeal, he said. He has already filed an.
That is why that appeal was.
Have you filed an appeal?
Yes.
Where it is? Where is the question of automatic? Where is your appeal? Where is your appeal?
A, my lord.
29?
Page 29A. It is photo, my lord. Raise an appeal. As per my lord, the Articles Act.
Not satisfied your application status, raise the grievance or submit new appeal.
29A, we don't have, my lord. We don't have 29A.
Last, my lord, page 30.
Page 30.
Page 30. The table.
It says appeal submitted by the Saniara Begum.
And the auto escalate. Auto escalate. And subsequently.
Auto escalation. What does it mean?
Last time, 2/1/26.
What does it mean? Not satisfied with your appeal status, raise the grievance or submit a new appeal.
Without any reasoning, that the appeal is auto escalate. And in the earlier case also, my lord, on that situation, the court was directed.
You provided this judgment to him. We'll continue at you go through this.
I'll
If
go.
it is same facts and issue, once it has been disposed of by the coordinate bench, will pass the same order.
My lord.
We're not saying that you should, allow this appeal, but you have to be, it has to be heard. You go through it.
I'll go through it.
We'll dispose of the matter if it's similar. Yes. Hmm.
Yes, on the petition of not they have applied for the mediation.
Hmm.
Has been rejected.
Hmm.
Against rejection.
Hmm.
While appeal was also not rejected. So then again they file an another.
Hmm.
Two ways with scope. Page 8.
Hmm. Page 8 of what? Hmm.
It says, Michael, that the petitioner state that after mediation application was rejected, and the past appeal was also escalated by system. The petitioner subsequently filed another appeal before the respondent number 116126 by split scope consignment number this day. This was delivered on 71126. But no response has been provided till. And with regard to this, my lord. My lord.
Annexure 8, my lord.
Annexure 8 and Annexure 8.
Hmm.
This is still pending according to them.
Hmm.
And then in that case, the direction can be passed if they have said this appeal. If a specific time that it is. Well, if because my lord, our
If it is received,
if it,
if it is not received,
then let them file another.
But my lord, in earlier case also, exactly similar appeal was filed by registered.
the appeal needs to be filed through the manual or by e-filing?
First appeal, it is e-filing, auto-generated, my lord.
Ah,
After rejection or delayed provide service.
yes.
And due to delayed, it is appeal is automatically provided to the higher authority, and query from the higher authority, the first authority rejected the main petition.
Hmm.
And subsequently, immediately on the next day.
Hmm.
This is the case. And the
Where it is? Where is the rejection?
rejection, my lord, page, rejected, my lord, page 29A. Rejected circle officer.
I don't know how it is.
Why it has been rejected, I think it's stated in our
You have said so. You have said.
yes. Page 35.
For mutation paper and did register nursing mills. As per principle. Have you submitted the NOC?
No, my lord.
Then
It is, my lord, when the registration was done, the law is amended. That is, my lord, I annexed that registration act. At page, my lord,
why are you saying that the similar matter, similar area?
exactly similar. My petition is with my lord.
Huh? He said it's
That
a different.
earlier petition is also, my lord, with me.
Some right to public service should be followed. Procedure for application for the first or second appeal. But is according to his feeling, first appeal has also been rejected. Yes, finally second appeal. It says by law, every first or second appeal petition in the case may be that specify the following profession. Name, address, or applicant or person preparing the first and second appeal. To the extent possible, name and address of the designated public servant or person or agency, or the appellant authority against whose action or decision the first and second appeal has been prepared. Particular from the order, date of application, ground from first or second appeal, the relief sought for, any other related information. But it never says that my appeal is filed to speech force concerning.
But the manner you have considered and rejected is one line,
But it says, my lord, the release says.
not even one line, is two words. What's the, how it can be justified?
Only one word rejection, my lord.
Two words.
Consider the second appeal, other appeal, the specific time. That can be also possible. Giving in details, taking out of.
Either here, nor there.
Otherwise, tendency of this application is not served in.
Hmm?
Tendency of this application is served is not possible.
Yes. Heard Mr.
K.U. Ahmed.
K.U. Ahmed, learned counsel for the petitioner. And also heard Mr. N. Das, A. Bhattacharya and Mr. Learned State Council Revenue Department. And Mr. N.C. Das, N. Das, learned counsel for the petitioner. And learned for respondent number, State Council for respondent number 2 and 3. Next paragraph. The grievance raised by the petitioner is to the effect that a direction may be issued to the respondent the circle officer,
My lord.
Barnagar Revenue Circle, to mutate the name of the petitioner in the land records of rights against a plot of land measuring 2 bigha 4 kata 13 lesser, covered by DAG number 845 under KP Patta number 136, situated at Revenue Village, Kairabari, Moja, Gabardana under Barnagar Revenue Circle, in the district of Barpeta. Page 10, schedule of next paragraph. The petitioner and the petitioner contends that he has purchased a plot of land measuring 2 bigha 4 kata 12 inches, so and so, DAG number same. Pro 1 Srimati
Yes, my lord.
Rani Bala Basak, a resident of ward number 15, POPS, Barpeta, Barpeta district, for a consideration of rupees 50,000.
No, my lord. 29 lakhs 70,000.
29 lakhs 70,000, including one Assam type house. List of the please, after the no, Mr. Thereafter, an application was filed before the sub-register office, Sorbok, visited the spot. And then issued the valuation certificate dated 07/11/2022 in respect of the land and house list of the sale deed was registered on 17/11/2022 by serial number 956 and registered deed number 857.
847.
847, and the cast position was handed over to the petitioner. List of the next petitioner, after execution of the sale registered sale deed, applied for mutation of the land in his name in the land record of rights. Seva Setu, within the Assam on 8/09/2025. With an online acknowledgement being number RTPS MUTD /2025, page 6, para 6. With an indication that same shall be provided within 16 days from the date of application. However, even after lapse of 60 days, the name of the petitioner is not been mutated in the land record rights. Next paragraph. The rejection of the next paragraph. List of the respondent number 3 has rejected the mutation application on the ground that by an order dated 01/12/2025 on the ground that no NOC has been submitted from the Deputy Commissioner's office. List of which was list of thereafter. It is shown that the first appeal was auto escalated by the system on 02/12/2025. There's a second appeal again.
Yes, madam.
Where is your application?
Application, my lord, page 31, my lord.
31. Thereafter, the petitioner submitted an application before the Commissioner Secretary, Revenue and Disaster Management Department against the rejection of mutation application by the respondent number 3. on the ground that you have submitted the NOC, no?
No, my lord.
No NOC, no objection certificate is required. List of. Hmm.
Application for equation and appeal dated 22/11 along with the rejection of.
Hmm. 32?
Yes, sorry. Last two.
Hmm.
Enclosed, my lord, bottom.
These are the documents submitted along.
Along with the second tab.
Hmm. List of. Next paragraph, Mr.
K.U. Ahmed.
K. Ahmad, learned counsel for the petitioner submits that since the petitioner has purchased the land and the sale deed has been duly registered along with other relevant and the said documents along with other requirements, requisite documents having been submitted for mutation in his name, comma, this, no, the rejection of the application, mutation application on the ground of non-submission of NOC is illegal and the and there is no as there is no requirement of submission of NOC as per the relevant provisions of law. List of. He submits that the respondent authorities have mechanically rejected the appeal by simply where is that rejection? Second appeal? Page
Second
30.
appeal, second appeal not rejected, my lord.
First appeal.
Okay, No, then in the two by mechanically by showing by indicating auto escalated, which violates the principle of natural justice, as there is no proper hearing to the petitioner. He submits that the respondent authorities are sitting over the second appeal and no decision has been, no steps has been initiated to hear the second appeal by the petitioner. Next paragraph, Mr. N. Thus, learned counsel for the learned state counsel, referring to the affidavit filed by the respondent number 2 submits that the as per the provision of section 21A under the registration within bracket Assam Amendment bracket Act 2009. The deed of register of agricultural land deed of registration of agricultural land without NOC is restricted, and the present land is a mutation application, mutation. No, mutation application, and the present land and the land in question is agricultural class 2. Therefore, the mutation application was cancelled by the circle officer in accordance with the provisions of law. Rejected, However, he fairly submits that the second appeal filed by respondents is required to be heard and considered by the
If so, fine.
respondent authorities if it is filed and pending before the appropriate authority. Next paragraph. The no, it is not disputed. No, it is not in dispute that the petitioner has purchased the so and so land from one so and so land, for a consideration of so and so 29 lakhs, including Assam type house. Thereafter, a valuation certificate was issued, and accordingly, the deed of registered, the sale deed was registered. List of the issue. Next para, which engaged the attention of this court, and in fact raised by the petitioner, is to the effect that the authorities has failed to consider the second appeal against the rejection of the mutation application. Would not fail to consider as it would be incumbent upon the appellate appropriate authority to consider the appeal as the relevant provisions of law requires. The relevant provision provides the remedy of an appeal against the rejection of the mutation application. Having considered that the authorities are incumbent upon to consider here and consider the appeal against the rejection of the mutation application filed by the petitioner in terms of the applicable, in terms of the provisions of applicable rules, as the petitioner is entitled to be heard by following the principle of natural justice, I deem it appropriate to dispose of this petition with the direction to the respondent. Who is the authority? Respondent number one. The respondent authorities, particularly the secretary and commissioner and secretary, Revenue and Disaster Management Department, Government of Assam, to take up the appeal, second appeal filed by the petitioner, and here the same by providing an opportunity to the petitioner of being heard list of, in case the appeal is not filed, in case the appeal, no, in case the appeal filed by the second appeal filed by the petitioner is not on the record, the petitioner be permitted to file a fresh appeal, press appeal before the appellate authority. Yes.
Paragraph 5 of the report. And say that he has registered the second on
You consider everything, it's okay. What minute, 1 minute, it will take another 10 minutes. Yes. I have given you enough time. You have not, after I complete the dictation, you are making a submission. What?
He has registered on 70
Huh.
but prior to that, page 25, that amendment act
Huh.
states that for any registration of the document, NOC is required.
So you decide that.
if registration was done.
Ah.
NOC.
Hmm.
So it cannot be mutated at this stage.
Hmm.
He has to approve to register once again.
Hmm.
And after getting the NOC, he has to register it again. That is the only way out. Otherwise,
Then permitted to file the fresh appeal. Next paragraph. It is ordered accordingly, huh? The exercise directed herein above shall be completed within a period of 2 months from today. Repetition is not allowed in this. This will stand this part.
it's not his problem.
Hmm?
It's not-
Appeal, second appeal, why we see, suppose if the appeal is not on record, we have permitted, you have to permit him to file a second appeal. Why you say this order should go along? It's up to you.
Obliged.
Yes, next.
40,
14?
41.
Okay. 41. 14, yes.
May I please, Your Lordship?
Yes.
This issue is already decided by the division bench judgment of this honorable court.
Yes.
Lordship, the next judgment I have next in page 130.
Hmm.
The division bench has already decided the issue in the favor of the SSC. And Lordship, at page 130, Lordship will kindly see.
What is the issue?
Lordship, the issue is that, Lordship.
I don't know what is the, we don't know what is the issue.
Lordship, what has happened is that, Lordship, I am a buyer. And Lordship, the selling dealer has failed to deposit. I have.
Any order has been passed?
Lordship, this is the, yes, Your Lordship, the order in original is at page.
I'll ask them to you go through the judgment of division bench and will.
Lordship, I think so they will agree because division bench judgment was passed in their presence. Lordship, whether if they say it can be disposed of today itself, Lordship. I hope my counsel is online. If it is Lordship covered, then Lordship, it's covered by division bench judgment of this court.
Yes. Yes, yes.
Lordship, I am appearing on behalf of GST.
Yes. Tell us.
And I have seen the judgment 130.
Hmm.
And that judgment also covered the seller dealer for to deposit tax processing dealer cannot be punishable from this GST Act, my lord.
Hmm.
And our 128 is the punitive order where they have to pay the amount. 128 and 129 where order in original, your lordship. They have
Yes.
to pay the amount of rupees 69 lakhs 56,794. 128, my lord.
158.
128.
128.
128.
Yes.
That order is that one, your lordship. The demand of rupees 69 lakhs 56,794.
Hmm.
Along with penalty is 68 lakhs 56,794 at page 129, my lord. And that order was issued on 23/3/2024.
Starting from page
129.
order in original, starting from page
Lordship, page 109.
109. You are challenging this.
I am challenging this, and Lordship, it is covered by the judgment, Lordship.
It's okay, one by one, madam.
Yes,
It's
Your
a
Lordship.
motion matter.
Yes, Your Lordship.
Just wait for it. This 28/3/2024.
Yes, Your Lordship.
Why so late?
Lordship, I had been writing I have written a letter to them that this is covered by the judgment, but they said that you have to file a writ petition and get it set aside.
Huh?
It's covered by the judgment of the division bench of this honorable court, but they said that you have to file a writ petition to get
So,
it set aside.
Mr. Gogoi, Dr. Gogoi,
Lordship. Lordship.
Are you agree?
Yes, Your Lordship, it shows
Agreement.
like, yes,
The issue has been decided. We'll set aside this order. A similar order
Lordship.
will be passed. We'll grant
Lordship.
the similar relief to the
Lordship.
petitioner. All right.
Lordship. Lordship.
Okay. Heard MS and Havali learn counsel for the petitioner, and also heard Mr. Doctor
Lordship.
Ian Gogoi, learned standing counsel, GST,
Lordship.
for all the respondents.
Lordship.
Challenge made in this writ petition is to the order in original number, page 109, huh? So and so dated 28/03/2024, passed by the
Assistant Commissioner,
Assistant Commissioner
Silchar.
Silser, whereby how much?
69,56,794.
Lordship, the amount is at page 129, last question order.
Ah,
Confirm the demand of 69,56,790.
whereby an amount of rupees 69,56,794
For 2018, 890.
on the petition under so and so, huh? Page 120. Huh? Is so to be levied, huh? Next paragraph. Next paragraph. Having considered that the similar method has already been decided by a division bench of this court. Division bench,
Yes, Your Lordship, division bench.
page 130.
Yes, Your Lordship.
And also, and as agreed to by the counsel for the parties, this writ petition is taken up, and this petition is heard and disposed of at the motion stage itself. Pass the order.
Lordship, only that assessment year is 1819, 19.
1819, huh? For the financial year 2000. Assessment year 2018 to 19.
So 2017 to 19, so Lordship.
Okay,
2017 to 19.
17, 18,
18.
2018, 19. Dispose of.
Lordship.
Deeply obliged.
I get 70.
17? Okay. Okay, Partha. Yes. No issue. No issue. Otherwise also, because of this, we're already in the motion matters. Still we're taking up motion. Hopefully it will be completed today only. It will be completed today. You'll complete it today. Yes, yes. Okay.
The last order.
Yes. On the
Argument from both second paragraph.
Ah.
Arguments from both the sides are completed except from the point of power to remove difficulties under center. 13 of the right to fair.
yes, yes.
At the learned piece of district judge forwarded by the EP judge order and held the right to fair competition. He agreed for these order to district issue is only on this point I have to address.
Yes.
But we appreciate I have some time from Lordship because I have to place the provisions in the right perspective and what is the distinction between right to acquisition of land and right to use of land. So there is a fundamental difference between these two concepts. So all these things cropped up because suddenly this notification was placed the other day of 28 August 2015.
Yes.
I have brought it both this.
Yes, yes.
May I read this notification?
Yes.
Whereas the right to fair compensation and transparency in land acquisition we have seen with the Agreement Act 2013 came into effect on 1 July 2014, and whereas subsection 3 of section 105 of RFP LIR Act provided for issuing notification to make provisions for the act relating to the determination of compensation, rehabilitation and resettlement applicable to cases of land acquisition under enactment specified in fourth schedule of the RFP award. And whereas the notification envisages under subsection 3 of section 105 of the RFP LAR Act was
Yes,
the
Yes.
RFP LAR amendment
just one. 2013 Act. Yes, please continue. Please continue.
subsection 12 of the Act.
Hmm.
Ordinance 2014 was promulgated on 31st December 2014, hereby entering amending section 105 of the RFCLAR Act to extend the provisions of the Act relating to the determination of compensation and rehabilitation and resettlement of the cases of land acquisition under the enactment specified in fourth schedule of RFP LLR Act 2000. Here is object. Also, kindly mark this word in cases of land acquisition. Second line, the second word, third word, land acquisition.
Hmm.
And whereas RF Amendment Ordinance 2015 was promulgated on 3rd April 2015 to brief continuity of the provisions of RFLR Amendment Ordinance 2014. And whereas the RFR Amendment Second Ordinance 2015 was promulgated on 30th May 2015 to give continuity to the provisions of the Amendment Ordinance 2015. And whereas the replacement bill relating to RFCLAR Amendment Ordinance 2015 was referred to Joint Committee of the House for examination and report, and same is pending with the Joint Committee. And whereas as per the provisions of Article 123 of the Constitution, the RF amendment or second ordinance shall lapse on 31st day of August 2015, and thereby placing the land owners at the disadvantageous position, resulting in denial of benefits of enhanced compensation and rehabilitation and resettlement of the cases of land acquisition. Again, mark this word, land acquisition, under the 13 Acts specified in the fourth schedule of RFLR Act as extended to the landowners under the said ordinance. Whereas the central government considered it necessary to extend the benefit available to the landowners under RFLAR Act to similarly place landowners whose lands were acquired under the 13 enactments specified in the fourth schedule, and accordingly the central government, keeping in view of the aforesaid difficulties, has decided to extend the beneficial advantage to the landowners and uniformly apply the beneficial provisions of RFLAR Act relating to the determination of compensation, rehabilitation and resettlement as well made applicable to cases of land acquisition. Notes will again mark this word, land acquisition, under the said enactments in the interest of landowners. Now, therefore, in exercise of the power conferred in subsection 1 of section 113 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013, the central government hereby makes the following order to remove the aforesaid difficulties, namely, this order may be called the right to fair compensation, transparency in land acquisition, rehabilitation and resettlement difficulties order. It shall come into force with effect from 1st day of September 2015. The provision of the right to fair compensation and transparency Act in land acquisition, rehabilitation and resettlement Act 2013 relating to determination of compensation in accordance with the first schedule, rehabilitation and resettlement in accordance with the second schedule, and infrastructure amenities in accordance with the third schedule shall apply to all cases of land acquisition under the enactment specified in the fourth schedule of the said act. Here also the previous line, the land acquisition what possibly might below. So this notification expands the scope of compensation relating to land acquisition as well as for rehabilitation and resettlement to the 13 number of acts which are placed at fourth schedule. What you will see, the fourth schedule in terms of section 113
5,
Serial number 8.
serial number 8 is there. So there are about 13 acts.
Yes.
So in all these 13 acts, when there is a case of land acquisition, the benefit of compensation computation
Hmm.
will be done as per the 2013 of the 14 Act.
Hmm.
So that is my case. So where there is a acquisition under any one of these 13 acts, in that situation, the land compensation, rehabilitation, as well as resettlement will be done in terms of the 2014 Land Acquisition Act.
Hmm.
In our case, it is not a case of land acquisition.
Is
That
it,
is the,
this is a case of what?
this is a case of land, this is right to use of land.
There is also acquisition of right to use
There
the
is
land.
not difference. I will place the judgment of the
Okay. So according to you,
The ownership, there is a fundamental difference.
according to
Fundamental.
acquisition of right of user and the land acquisition is
Yes, Lord.
different and distinct.
Lordship may raise that issue, but my submission is.
No, I am asking you. That is what you are trying to.
Yes, my case is right to use of land is different from right to acquire land.
Huh.
Where. what
That is exactly
acquired-
I'm saying.
Yes, that is. So there is a huge difference. The ownership, title and possession remains with the landowner.
Hmm.
Under the Act of 62.
Hmm.
PMP Act. So the ownership has not changed, land has not been acquired. There are a bundle of rights of the owner, one particular right has been taken away. That will not amount to acquisition of land. So to that effect, I will place the Supreme Court judgment.
Therefore, the 13 Act will not apply.
This
In the-
benefit will not apply.
Cannot be applied.
Under the PMP Act.
Hmm.
Under the PMP Act also, if a land is acquired,
Hmm.
then the compensation has to be assessed in terms of the 2014 Act.
PMP, there cannot be, if we
Exactly.
I mean, accept your submission. I mean, under PMP, there cannot be acquisition of land.
Directly, no.
I mean, taking your, I'm
Yes,
accepting
There is no scope.
your
of-
submission.
But in case, suppose, while laying the pipeline, if a pump station has to be stationed within that land,
Hmm.
then that particular area of land will be permanently acquired. That is also considered by the Honorable Supreme Court. In that situation, the compensation of that particular.
That will amount to acquisition,
That will amount to
acquisition of land.
Yes. Otherwise.
Then in that case, the nomenclature itself would be, I mean, it will become redundant.
Which
This PMP Act.
PMP Act, there are 13 acts.
Okay.
13 acts are there. So they did not minutely look into all the aspects of each of the acts.
No, what I'm trying.
Now Lordship will have to examine.
Hmm.
And in a case of the other act,
Hmm.
there are 13 acts.
Hmm.
When I will place the judgment, everything will become crystal clear.
No, I'm clear, but what I'm trying to
From
make
the
my.
judicial pronouncement.
Huh. Yes.
Now.
I'm clear about your
suppose
submission,
they
but
have
I want to make myself more clear.
Yes, Lordship, I will try to assist this.
I've understood. Yes.
Even I was not clear the other day.
Yes.
After going to two judgments, it has been crystal clear for me.
Okay.
Now, suppose the Ancient Monuments and Archaeological Sites and Remains Act 1958.
Hmm.
A land has been taken under this act.
Hmm.
This is a religious endowment area.
Hmm.
In that case, the acquisition has to be done. In
Hmm.
that situation, suppose the private families are staying there,
Hmm.
and we have found a particular monument of ancient importance.
Hmm.
If that area is taken, then the compensation has to be assessed in terms of the 2014 Act.
Hmm.
Let us take down the Atomic Energy Act.
Hmm.
Suppose a particular uranium has been found in a particular area.
Hmm.
That area, that particular plot of land or parcel of land, if it has to be acquired under the Atomic Energy Act, that compensation has to be paid in terms of the Land Acquisition Act of 2014.
Hmm.
Damodar Valley Corporation Act,
Hmm.
the Indian Tramways Act,
Hmm.
Land Acquisition Mines Act,
Hmm.
Metro Railways Act, National Highways Act.
Yes.
These are all individual and special acts.
Hmm.
But suppose for National Highway,
the land has been acquired by the government for construction of the highway.
Hmm.
That land will be assessed for the purpose of compensation, rehabilitation and resettlement.
Hmm.
It has to be done in terms of the 2014 Act. Then Petroleum and Mineral Pipelines Act, Requisition and Acquisition of Immovable Properties Act, Resettlement of Displaced Persons Land Acquisition Act,
Yes.
Coal Bearing Areas Acquisition and Development Act, Electricity Act. Suppose a tower has to be done, placed there
Hmm.
in that land. Overhead wires, it will not come under this.
Hmm.
But if a tower has to be placed there,
Hmm.
in that case, the compensation has to be assessed.
Hmm.
Then Railways Act. Is serial number E. So Petroleum and Mineral Act, for that purpose, if the pipeline goes below the subsoil,
Hmm.
the owner only restriction he will face is that in that particular plot of land, in that area, he cannot construct a house, but he can construct a house adjacent to it. The possession, the surface possession will lie with him. Ownership will lie with him. Everything will except he is restricted from digging that particular pipeline area. 5 feet this side, 5 feet that side.
Therefore, this acquisition under the PMP will not comes under the phraseology or the expression of land acquisition.
Otherwise, no. It is only
Therefore, 10 the
it come. Suppose under this act, a pipeline has been constructed, and in some area there has to be some pumping station. Suppose in the High Court complex, the pipeline goes and the station has to be installed there for continuous supply of the pipelines for various junctions and various supplies. In that area, in that case, that particular land will have to be acquired under this act, and compensation has to be paid under the 2014 Act.
13 Act.
That has been clarified by the Supreme Court.
13 Act. Okay.
Whatever I am submitting, I am taking into assessment. So may I place that judgment?
So therefore, if the land, even under this act, is acquired.
It is not acquired.
No, if it is acquired.
Right to use has been acquired.
No, if it is, if the particular land, even under this act is acquired,
Then compensation will.
compensation has to be paid, and the as per
limited compensation has to be.
2013 Act.
Otherwise, if that has to be done, that it will be an astronomical amount the government will have to pay to all the landowners who are having the pipelines within their area. To reduce that particular quantum of compensation.
Therefore, in essence,
Very limited.
that's why in essence, what your submission, your submission is that the acquisition of right of user cannot be compared, or rather, it is different, totally different from acquisition of a land.
Exactly.
Therefore, if the acquisition is only of right of user in the land,
Exactly.
therefore the 2013 will not apply.
It will not.
That is your
That is
precise
the case.
point. Yes.
And he is not dispossessed from his land.
Hmm.
If it is acquired, if a particular plot of land is acquired, he is dispossessed. He do not have the title changes, ownership changes. Here everything remains intact, except one limited right has been taken away from him, that he cannot construct house or he cannot build in that area or dig in that area. So I'd like to place this where this act was in detail explained, that is Lalji Bhai, Sada Bhai, Savalia and others versus State of Gujarat, 2016.
Lalji Bhai.
Lalji Bhai's case, 2016, 9, volume 9 SCC, page 791. The relevant paragraph will be lordship, 19, 20, 21, 24, 32, 33. May I place this?
Yes.
Paragraph 19. Yes.
Paragraph 19.
Paragraph 19 onwards.
19, 20.
19, 20, and 21, 24, 32, 33.
Is PMP Act.
PNP Act.
Then 30, para.
32, 33.
It's okay. I'll go through it. I'll go through it. It's okay.
Sir, I have to make my argument.
I've understood. I've understood your submission.
Only paragraph 20. Only,
Okay. Para 20.
Yeah.
Okay.
19 and 20, let me read it.
Okay.
Otherwise, yes, Lordship will.
Yes.
The statement and objects and reasons go like on this facet of this matter and shows that although the land could be acquired outright for laying such pipelines under the Land Acquisition Act, such procedure for acquisition would be costly. This is what I was submitting. For instance, as the fact of the present case disclose the pipeline from Kakinada to Jamnagar would be over 1470 kilometers inland. If the land were to be acquired outright, it would lead to tremendous increase in cost, finally reflecting in escalation of the cost of petroleum or minerals. Ultimately, public will have to pay. At the same time, if every stage outright acquisition is to be insisted upon, many agriculturists would stand deprived of their holding, causing great prejudice. The other side will also be affected. The act is thus designed to achieve the purpose of laying the pipelines for petroleum and minerals as efficient and cheap means of transportation and distribution of petroleum and petroleum products. At the same time, Section 18 specifically lays down the provisions of PMP Act shall be in addition and not in derogation of any other law for the kind in force relating to acquisition of land. Thus, in a given case where the circumstances and occasions so demand, a resort could still be taken to acquire lands by relying upon the general law of acquisition under the provisions of Land Acquisition Act. For instance, for monitoring the pressure gauges or in case where pipelines are branching in different directions, implementation to regulate the flow may require permanent establishment, necessity, acquisition of land itself, rather than acquisition of a mere right to users. The PMP Act is thus a special enactment designed to achieve the purpose of laying pipelines as efficient means of transportation, and with this idea, it is only the right of users in the land to lay such pipeline is acquired. The remaining paragraphs basically distinguishes between right of ownership and right of user. So this is the basic object and reasons. And the act is sufficient enough to give the total how the principles has to, what will be the principle on the basis of compensation has to be assessed or determined. Because very limited right is taken away.
Yes.
So my humble submission is that there is a fundamental difference of right to use of land and acquisition of land. The notification which the other side was placing, I have already indicated that the whole notification is in respect of acquisition of land. Lordship has already marked those. In every paragraph, it is acquisition of land, and in that case only, the first schedule, second schedule, and third schedule will be applicable for the purpose of assessing the compensation. The other judgment which the other side plays, Lordship, if the whole judgment is read, Lordship, it will come in our favor. Nothing is going to their side, Lordship. Because they are relying upon this notification, and notification is very specific. This notification is applicable only when land is acquired under the any of the ordinance. So in their case, it is not a case of acquisition. It is the change of taking away the right of users for one limited purpose. So that is my case.
So, borrowing the words from the Supreme Court judgment, that is outright acquisition. Outright acquisition.
Outright acquisition. That is not.
If only it is on an outright acquisition only, then only 13 will apply.
13 will apply.
Not for user. right of user, acquisition for right of user. Yes,
So this is my question, the fundamental data I have made a short note.
okay.
This is what I have just argued.
It will be helpful for this court, although we have I have noted down. And what about the findings of the district judge?
District judge is right. Why? If lordship is crystal, 2 points have been covered. Notification cannot be a notification under section 130. The reason is very clear. The notification has been issued without taking a cue from the judgment of the Bombay High Court, which he was referring. If lordship is to see, this is a notification under subsection 3 of section 105. Lordship will kindly see at section 105. Subsection 3 of section 105 says, the central government shall, by notification within 1 year from the date of commencement of this act, when this 1/1/2014 this act came into force, and this notification is of 28 August 2015. So it is beyond 1 year. Number one, lordship will go to subsection 4.
Just wait. August 2015.
So it is beyond 1 year.
No. They said central government shall by notice within 1 year from the date of commencement of this act. The act commenced from 1st January 2024.
No.
Yes.
2014.
Sorry, 2014. This notification was up to August 2015.
1 year, 10 months later. August 2015.
Okay.
Act is of 2013. It came to effect from 1st January 2014.
14.
And
Then
this
it will-
notification is of 28 August 2015.
When the ordinance was promulgated?
Ordinance was promulgated in 2014.
14, yes.
But notification was not there. So we have to get the notification. The
Sir.
notification is of 28 August.
3rd December 2024.
And also, subsection 4 says a copy of every notification proposed to be issued under subsection 3 shall be laid in draft for each House of Parliament. The central government will be able to tell
So once the ordinance was promulgated, within 1 year,
whether promulgation of the ordinance is equivalent to issuance of notification. It is not same.
not the issuance of notification,
The language is very
the
clear.
the clarification and the amendment.
That's why I did not argue in the first place. But otherwise also, without taking a cue from the judgment of the Supreme Court, one of the High Court, Bombay High Court, why?
And how the court can return with a finding that
But
the
our case is very simple.
Hmm.
Here there is no case of acquisition.
No, that I've understood.
Yes.
We'll examine it,
Yes.
but I would like to, from the academic point of view, suppose if the ordinance, yes, once ordinance is promulgated within the stipulated period, the subsequent notification is
The promulgation of notification,
ordinance.
it has to culminate into the form of a notification or a.
Ultimately, it has been culminated, maybe beyond 1 year. According to you, the time limit has to be computed taking into account of the actual notification,
Whether
not the date of ordinance.
Ordinance we can prevail over the specific provision of section 105 subsection 3. The notification and ordinance cannot be placed in the same platform.
Obviously. Anyway. So according to you, this is not even in as per the subsection 3 of the 105.
That is my sub.
Therefore, it could not have been issued.
From that perspective, the learned district judge was correct.
But he could not, he should not have gone beyond that.
Of course,
Because
he,
that
it's,
was not his subject.
of course, it's not his own findings. It is based on the decision of the
But that-
Bombay High Court.
In fact, in my humble submission, that was not the actual lease. The lease was something different.
I've understood. But then why he has to decide that?
Yes. That, that I cannot.
Why the
comment.
district court has to
When
decide that?
He has
When
gone
the-
beyond his brief,
Yes.
but within his brief, he has done something. He said that this is a premature. Yes, it is premature because compensation has not been assessed. First, there are three brothers and they have issues within their family. Now one has come before this honorable court.
Other two brothers have no issue.
We have stated all those things in our.
Okay.
Those are at the micro level. I
Ah.
am talking about the macro level. In
Okay.
macro level, not whatever, lordship that is, because ultimately, if it is acquisition, its notification will. If it is not acquisition, then the other things will follow.
Yes.
The various principles, various protocols laid down in the PNP Act itself is sufficient to find out what will be the exact compensation. And lordship, I have just placed paragraph 19 and 20. What is the objects and objective and reasons of the act?
Otherwise, you
To
are
minimize the expenses of the government.
otherwise you are ready to pay the compensation or whatever in terms of the PMP Act. Okay.
We cannot say, if lordship directed, we have to pay another 14 also, we'll do that.
Hmm.
But whether they are entitled or not,
Okay.
till now that exercise has not been done.
Okay.
Highly obliged. My colleague will be there.
Yes.
Look, let me first deal with the last point first.
Hmm.
But my junior was present when the other side argued the case. He has taken note of, I'll reply to each and every point. Now, my lord, an argument is sought to be developed based on Lalji Bhai's case. My lord, a decision is an authority, what it actually decides. My lord, let us come to paragraph 15. What was the subject matter of the judgment, my lord?
Chajuram.
Yes, Lalji Bhai. Whether it was a case where Honorable Supreme Court was seized of a matter where the question arose whether it is a case of acquisition of land or whether it is a case of acquisition of user of land. Well, Lord, please come to para 15.
Of Lalji.
Yes. What was the case?
Yes.
Before we deal with the challenge raised in these appeals, it must be noted that none of the landowner challenged the validity of section 3(1) of the notification issued in the instant case, nor any grievance was raised against the order passed by the competent authority under section 5(2) of the PMP Act. So, my lord, regarding assessment of compensation, etc., nothing was put to challenge. Though a substantive writ petition challenging the virus of some of the provisions of PMP Act was filed, petition was also withdrawn without seeking any liberty. Even then, we have heard the submission regarding validity of the PMP Act. So, my lord, how certain observations made in this decision is applicable in our case?
Yes.
My lord, let me make one aspect very clear, my lord. Whether it is acquisition of land or whether it is acquisition of right of user, both are covered under 2013 Act. Let us not have any dispute on that. Now, my lord will kindly come to this 2010 Act. Sorry, PMP Act. Is your lordship having a copy of the PMP Act? I'll hand over, my lord. There's an extra copy.
Yes,
yes.
sorry.
Yes.
It's already there.
Yes. Now, let
I
me
just-
place few provisions, my lord. Please come to the preamble of the Act.
Just wait. Where is that bunch of petition? Bunch of papers, not this one. Yesterday there was, maybe in some other papers. Huh. You just compile it. You compile it, keep it separately. Okay. I think something more is there.
Well, I'm having a copy.
No, I have this.
Oh.
Okay, okay.
Hold on a second.
Oh, this is from here only?
Yeah.
Yes, yeah. It was already.
Yes.
It's
Yes.
already here.
Yes.
Last occasion you have played.
An act to provide for acquisition of right to user in land. So, Milord, this is an act expressly providing for acquisition of right of user.
Hmm.
Then Milord will kindly come to say definition section 2A.
Hmm.
A competent authority has been defined. Competent authority means any person or authority authorized by the central government by notification in the official gazette to perform the functions of the competent authority under this act, and different persons or authorities may be authorized to perform all or any of the functions of the competent authority under this act in the same area or different areas specified in the notification. So, Malab, there is a concept of competent authority. I have referred to this provision because an argument has been advanced that against the order of district judge, writ petition does not lie. I'll deal with that, Milord. For that, I have drawn your lordship's attention to this this provision. Then Milord will kindly come to section 6.
Yes.
Where no objection under subsection 1 of section 5 have been made to the competent authority within the period specified therein, or where the competent authority was disallowed the objections under subsection 2 of that section, that authority shall, as soon as may be, either make a report in respect of the land described in the notification under subsection 1 of section 3, or make different reports in respect of different parcels of such land to the central government containing his recommendation to the objections together with the records of the proceedings held by him for the decisions of that government, and upon receipt of such report of the central government shall, if satisfied that such land is required for laying any pipeline for the transport of petroleum, declare by notification in the official gazette the right of user in the land for laying pipeline should be acquired. So, my lord, why a declaration will be made after complying with the formalities envisaged in the act, my lord? Central government's permission is obtained, then a declaration will be made for acquisition of the right of user. But nevertheless, my lord, whether it is acquisition of land or it is acquisition of right of user, it involves computation of a compensation. If it involves in computation of Milord compensation, then section 13 will definitely apply. Now, Milord will kindly come to section 10, which is very important. Section 10, subsection 1 and subsection 3. Where in exercise of the power conferred by section 4, 7 or 8, by any person, any damage, loss or injury is sustained by any person interested in the land under which pipeline is proposed to be or has been laid, the central government, the state government or corporation, as the case may be, shall be liable to pay compensation to such person for any such damage, loss or injury, the amount of which shall be determined by the competent authority in the first instance. So, my lord, subsection 1 of section 10 envisages a situation where, on account of acquisition of right to user, there the owner of the land could suffer damage, loss or injury. And for those three, on those three head, my lord, compensation is payable. Am I clear, my lord?
Yes, yes.
Then kindly come to subsection 3.
Yes.
The competent authority or the district judge, while determining the compensation under subsection 1 or subsection 2, as the case may be, shall have due regard to the damage or loss sustained by any person interested in the land by reason of removal of tree, standing crop on the land while exercising the power under so and so, temporary severance of the land which the pipeline has been laid from other lands belonging to an occupation of such person, any injury to any other property, whether movable or immovable, or the earnings of such person caused in any manner. So, my lord, in addition to damage, loss, or injury, which is envisaged in subsection 1 of section 10, the Act also envisages a situation under subsection 3 where the owner of the land, on account of acquisition of the right to user, can suffer the situation visualized by clauses 1, 2, and 3. Am I clear, my lord? So, for this, acquisition can take place. Now, my lord, the argument is, here we are not acquiring land. All that we are doing is, we are acquiring right of user. They have not used that expression right of user, but the emphasis was, it is not a case of acquisition of land. Therefore, 2013 Act will not apply. Lord, we'll kindly have the 2013 Act for a moment. Come to the fourth schedule. Kindly come to the fourth schedule.
Yes.
Serial number 8. The petroleum mineral pipeline, so acquisition of right of user land, 1962. So, my lord, any amount of argument from our side will be fallacious. For the simple reason, Parliament in its wisdom thought that this act of PMP Act must be included in the fourth schedule, and it has been done. Therefore, the consequence of section 105 or 113 has to be, Lord, given a due deference to the Honorable Court. Now, where is the scope of argument that when it comes to acquisition of land, only 2013 Act will apply? Well, Lord, this, as your Lordship has very rightly pointed out, that it is not a case of acquisition of land as is contemplated by either LA Act of 1894 or other acts, or National Highway Authority Act, etc. Here is an act, it involves acquisition of right of user. Even then, Parliament in its wisdom thought that no, we must include the PMP Act in the fourth schedule. In case, my lord, a removal of difficulty order is passed as contemplated in the Act, then the provision has to be, my lord, complied with. Now, my lord, my learned friend relied upon that judgment of Lalji Bhai. Now, please come to that judgment. He has referred to 19 and 20. Now, please come to paragraph 23 and 24. This will clarify everything. Though this was a judgment where virus of the Act was upheld, my lord, nothing was done. And Lalji Bhai is a decision of the year 2016. Anyway, my lord, in the context of the case, my lord, if I lay a challenge to a particular provision, as is obtaining, lordship will also decide. But that whether that finding will have any bearing in our case. Now, please have come to page 812, my lord, para 23. We therefore proceed on the premise that right of users sought to be taken over under provisions of PMP Act amounts to acquisition of one of the facets of the right property rights which inhere in the owner occupier. For acquisition of such right of user, compensation in the prescribed in terms of section 10 of the PMP Act. There are two elements of compensation under section 10. The first part deals with damage, loss, or injury sustained by any owner occupier as a result of exercise of the power conferred by section 4, 7, and 8. That is to say, actual damage, loss, or injury sustained because of entry upon or digging or marking level and survey of the land under section 4, or while actual laying of the pipeline, including digging of trenches, carrying of requisite material for such operation under section 7, or any other stage of maintenance, examination, repairing, altering, removing pipeline, etc. The measure for determining such compensation is given with sufficient clarity in subsection 3 of section 10. The idea is to compensate the owner occupier for actual damage, loss, injury sustained by him as a result of operation carried out in terms of section 4, section 7 or 8. One of the indicia under subsection 3 could be injury to any other property, whether movable or immovable, or earnings of such person in any other manner. All possible acts as a result of which the damage, loss or injury could be so occasioned are taken care of and stipulated in the said subsection. Over and above such compensation for actual damage or injuries, additional compensation at the rate of 10% of the market value of the land is to be given to the owner occupier. Well, this is where Milord this soup inches. Why should I get 10% of the market value? This is where 13 Act will come below. So there are two elements. One is covered by subsection 1, other is covered by subsection 3. Over and above such compensation for actual damage, loss or injury, additional compensation at the rate of 10% of the market value of the land is to be given to the owner or under subsection 4 of the section 10 for taking over right of user of the land. Well, after this, my lord, will your lordship accept the argument of the other side? So, my lord, while assessing the additional compensation, that is 10% of the market value, we must lay our hand to section 13, sorry, 2013 Act. This is in essence, my lord, the prescription of the Act of 2013. My lord, it's an Act of 1962. My lord, 2013 Act is a progressive Act. It has taken note of so many things. It envisages notice, it envisages, my lord, rehabilitation. It's a progressive legislation. It is not a regressive statute like 1962 PMP Act. So, my lord, where this will go evaporate? This has to be there. Now, reading further, my lord, please come to Placitum F. This element of compensation is purely for acquisition of right of user simpliciter. Damage, loss or injury to the property is separately dealt with under first part of section 10 and has to be compensated in toto. Theoretically, it is possible that in a barren piece of land as a result of exercise of power under 4, 6 and 7, there may not be any damage or loss. However, compensation under subsection 4 for acquisition of right of user would still be independently payable. The expression in addition to compensation, if any, payable under subsection 1 clearly shows the intent that compensation for acquisition of right under user shall be in addition to the actual damage, loss, injury under the first part of section 10. This part will also be clear from para 3.3 of the statement and objects of reasons extracted above in so and so. Therefore, my lord, my humble submission is a reading of paragraph 23 of the Lalji-Bhai's decision makes it very clear that exercise under PMP Act are two in number. First, to assess the extent of loss, damage that has been caused, and secondly, to assess the market value for payment of that 10%. Then, my lord, will kindly come to paragraph 24, my lord. The provisions of PMP Act do specify the principle and the manner in which compensation is to be determined. Not only the actual damage, loss or injury suffered as a result of exercise of various activities in terms of section so and so, but additionally compensation linked to market value of land is to be given for acquisition of right of user of this land. This is for undertaking this exercise of assessing market value of the land, my lord, that we'll have to lay our hands to the prescription in section 2030, Act of 2030. Am I clear to your lordship, my lord? Therefore,
But then the market value can be assessed.
Yes.
Under this act also.
No, my lord. That's
the PMP Act.
I'm coming to that. Now,
Because if you say that this 2013 that will apply, in that case,
it is what I am saying. The parliament is saying.
Yes, everything has to be given. The notice, rehabilitation, resettlement, And the solution.
No, my lord. Now the question of determination of compensation.
Huh.
We are only concerned with, my lord, determination of compensation. What we objected? Because they themselves in the written statement, they accepted that Act 13 applies. I'll come to that. And because I was dealing with this particular point, because I was, my lord, I was very happy to deal with this point first. When I've seen that the last point is this, why not I deal as the first point? Now the argument of the other side is, in very nutshell, there is a distinction between acquisition of land and
And the
acquisition of
acquisition
right of user.
User in land.
Yes. Now, my lord, in acquiring right of user, there are two elements under the Act. One is assessing the extent of loss, damage, etc. Secondly, assessing the market value of the land for paying the 10% which is prescribed under the Act, which they are willing to pay. Now, we said this will not accept this 10% as is provided under PMP Act, but we want higher as envisaged under 2013 Act, because we'll get almost 400%. Na? Now, whatever we'll get is 10%. The moment we apply, my lord, 2013 Act, it will become 400%. Now, my lord, so therefore, my lord, to deal with this judgment, my lord, this judgment does not throw any light to, my lord, advance the cause which is sought to be pursued by the respondents, for the simple reason, for the proposition that 2013 Act cannot be applied, because 2013 Act applies only for in a case of acquisition of land. Nowhere, my lord, emanates from this judgment. So this judgment is not an authority for the proposition that here is a case, because it is a case of acquisition of right to user under PMP Act. Therefore, 2013 Act does not apply. So, my lord, my humble submission is their reliance on this judgment is neither here nor there. As I have already pointed out from para 15 of the judgment, here, my lord, nothing was challenged. Provision, the Act was put to challenge, it was withdrawn. Nevertheless, Supreme Court says, since a very important issue has been raised, therefore we will examine. So this is a judgment, my lord, where the Honorable Supreme Court has explained the purport of the PMP Act. From that, what we find is, my lord, as far as acquisition is concerned, there are two components. One is extent of loss, damage and injury. Second, assessment of market value. Our case is this assessment of market value that has to be done under the 2013 Act. Now, my lord, will kindly come to the Act of 2013. I have already placed, my lord, the fourth schedule, from which the Parliament's intention is very clear, that right of acquisition of right of user is also covered by this Act. Now, my lord, will kindly come to section 105 for a moment.
Yes. Yes.
Provisions of this Act do not apply in certain cases or to apply with certain modification. Subject to subsection 3, the provisions of this Act shall not apply to the annexment relating to land acquisition specified in the fourth schedule. So, my lord, subsection 1 clearly provides that in the normal circumstances, provisions of this Act will not apply to acquisition, be it of land or of right to user, apply to acts enumerated in fourth schedule. Now, please, it says, but subsection 1 is subject to subsection 3. Therefore, it is imperative to read subsection 3. Central government shall, by notification within 1 year from the date of commencement of the Act, direct that any of the provisions of this Act relating to determination of compensation in accordance with the first schedule and rehabilitation and resettlement specified in the second schedule and third schedule, being beneficial to the affected families, shall apply to the cases of land acquisition under enactment specified in fourth schedule, or shall apply with such exception or modification that do not reduce the compensation or dilute the provisions of this Act relating to compensation or rehabilitation and resettlement as may be prescribed in the notification as the case may be.
My lord, the exception which was taken note of by the Bombay High Court, based on which the learned additional district judge has passed the impugn order was, my lord, that if you want to invoke section 105, then you are to invoke within 1 year of the coming into force of the Act of 2013. And 2013 Act came into force on, my lord, 1/1/2014. Now, please come to section 113. If any difficulty arises in giving effect to the provisions of this part, now kindly see, my lord, this part also includes section 105. This miscellaneous provision, chapter 13, it includes both 105 and 113. If any difficulty arises in giving effect to the provisions of this part, the central government may, by order, make such provision or give such direction not inconsistent with the provisions of this Act as may appear to it to be necessary or expedient for removal of difficulty, provided that no such power shall be exercised after expiry of a period of 2 years from the date of commencement of this Act. Now, this order was issued, my lord, on 28/8/2015. This removal of or difficulty order of 2015, it was issued on, my lord, 28th of August 2015, that is within 2 years. Now, when the Parliament empowers the central government to issue an order towards removal of difficulties in relation to the acts mentioned in 4th schedule, then where can the additional district judge have any grievance, my lord? Was he espousing his own cause, or was he espousing the cause of my lord Gale? My lord Gale would definitely like to acquire property at a lower cost, but Parliament's intention is otherwise. Parliament's intention is that no, they should get better deal. Now, my lord, since under section 10(3), there is a requirement of making an assessment of market value, therefore, naturally, my lord, these provisions will apply. Provisions contained here in the 1st schedule and the 2nd schedule, Tolesium, etc. Now, that is the issue, my lord. Now, to rely upon Lalji Bhai to say that because this Act deals with acquisition of right of user, therefore 2013 Act will not apply. With respect, my lord, I could not follow that argument. 2013
So
Act.
according to you, the notification has to be issued within 1 year, making the application of the provision to the port schedule within 1 year. However, if the removal of difficulties is
then it is within 2
done
years.
within notification, it has to be within 2 years.
And it was
It's not simply under 105. It's a removal of difficulties under section 113.
It is a case of removal of
113.
Yes.
Okay.
Well, that's why while opening the argument, I placed one judgment of the Gujarat High Court and one judgment of the Honorable Supreme Court, my lord, where this provision was adopted. So therefore, my lord, to deal with the last point, my humble submission is, this is absolutely fallacious to say that it is not a case of acquisition of land, therefore 2013 Act will not apply. Well, at least I haven't found any authority or any provision of law which supports that proposition. That 2013 Act applies only for land acquisition. If 2013 Act applies only for land acquisition, why in the 4th schedule PMP Act was included? And why by the removal of difficulties order, it was said that in respect of PMP Act also we are issuing this notification. So therefore, my lord, this is absolutely wrong. Then coming to the other points, my lord. Now, my lord, the first point which was argued by the other side was that this writ petition is not maintainable. Why the writ petition is not maintainable? Because the order has been passed by the additional district judge already. My lord, the order which has been passed, which has been challenged. And we are not assailing an order of civil court. We are assailing an order of the competent authority within the meaning of section 2A of the PMP Act. Therefore, the bar of
filing a RFA or something does not arise.
So nomenclature has no relevance.
It's not, no, my lord, district
Is the
judge.
authority.
Yes, district judge is not a civil court. Now, my lord, kindly see, even under the, my lord, 2062 PMP Act, civil court jurisdiction has been barred. Please come to section 14 of the, my lord, PMP Act. Section 14. Save as otherwise expressly provided in this act, no civil court shall have jurisdiction in respect of any matter which the competent authority is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or proposed to be taken in pursuance of any power conferred under this act. So, my lord, when a competent authority decides an issue, maybe the competent authority's office is manned by an judicial officer of the rank of additional district judge or a district judge. Thereby does not mean that he is a civil court. He is a competent authority within the meaning of PMP Act. And therefore, my lord, where do we go? There's no appeal is provided under this act. Therefore, 226 is the only remedy. Therefore, the ground taken.
So according to your district judge or additional district judge, competent authority under the act.
Within the meaning of 2A.
Therefore, whether that has been conferred by the act.
Yes.
So if the nomenclature of the court is irrelevant.
Is irrelevant. So therefore, my lord, the point of alternative remedy also goes. And here, my lord, they rely on this Radheshyam judgment.
So the district judge has not acted as a civil court, but as a competent authority under the act.
Am I
so
clear?
it lies. Yes.
Here they rely upon Radheshyam's case. Lordship knows there was an amendment of the CPC sometimes in 2002, my lord, whereby a revision was barred if any application does not result in disposal. So, my lord, there were a lot many litigations of people started invoking 226, 227, read with 115, something like that. Then, my lord, Surya Devi, there was a judgment by the name of Surya Devi. That was a judgment by judges, two honorable judges, my lord, where it was said that normally a 226 petition would not lie against an order passed by the civil court. And that's very right, my lord. Then, my lord, another bench of the Supreme Court coordinate bench, my lord, doubted the proposition. Therefore, the matter was referred in Radheshyam Gupta. In Radheshyam Gupta, my lord, that principle of law was reiterated, whereby it was said, certiorari would not lie against an order passed by the district civil court, any civil court. So, my lord, how that judgment held here? Neither here nor there. So, my lord, district, maybe the person who acted as the competent authority is an additional district judge. He was not a civil judge. Therefore, it is not a case where, because the act itself says civil court jurisdiction has been barred. So therefore, to bringing in civil court analogy does not arise. Then, my lord, they say, my lord, that the case which they filed before the additional district judge is premature. When you say we are entitled to compensation under the PMP Act, not under the 2013 Act, then, my lord, where is the question of premature? Now, there is a list, that list is to be decided. Now, kindly see, my lord, please come to page 67 of the petition. They are arguing that 13 Act does not apply. Whether they have read their pleadings, I don't know. Please come to page 67. Para 5, my lord. Compensation has been determined and declared by competent authority as per PMP Act. Petitioner is verified as one of the 3 beneficiaries in the affected area under DAG as per the joint verification report carried out by the representative of the circle officer, Gaubura, Latmondol, representative of competent authority, Gale, representative and Lennon. However, as he has not signed the Panchnama and submitted the required document, so and so, only his compensation has been pending in DAG
notified the compensation to other two beneficiaries have already been disbursed to them by the competent authority. If somebody chooses not to assert his legal right, that is not my problem. If somebody, I'm repeating in my lord, if somebody chooses not to assert his legal right, it can't be my problem. It is the problem of either Gail or two other persons. Then my lord will kindly come to,
But they are your brothers.
maybe, my lord. I am asserting my right. There cannot be any estoppel against law, my lord. Who can, Gail cannot say my two brothers have accepted and maybe they are filthy rich, my lord. I am not rich, I am a poor man. I need more money.
Why
And
you
the
are
third-
why you are poor? Your brothers, if the brothers are rich,
It happens, my lord.
they are
Five
stingy.
fingers are not same, my lord.
Are your brothers are very stingy, not sharing with the pursuits and wealth of
Yes. Now, my
their,
lord will
their
kindly come
pursuits
to,
and wealth.
now kindly come to their written statement, page 73.
Hmm.
Sorry, this is a letter, na? This was a letter written by the competent authority.
Yes.
Besides, for the purpose of determining of compensation, the market value thus obtained is calculated in line with the first schedule of Right to Fair Compensation and Transparency in Land Acquisition and Rehabilitation Act. In this regard, the market value is multiplied by factor 2, while an equivalent solicium is added to the compensation, thus allowing the affected landowner to get compensation at the rate of 10% of 4 times. That is 40% of the market value declared by district administration. This methodology has been uniformly followed in all districts of Assam and other projects of GAIL. For your perusal, a simple award calculation is attached here. Now here the argument is 2013 Act does not apply and their letter says they have applied 13 Act. And whom to accept, my lord? The authority or the lawyer? Kindly see the dichotomy. They themselves say they have invoked 2013 Act and they're making the argument. Please come to another paragraph, my lord, page 82. No, 82 no. That 76. 76, my lord. I'm sorry. Page 76. The whole first schedule has been, my lord, bodily lifted from the schedule of the Act of 2013 and it has been made a part of the written statement in support of the proposition that 2013 Act applies. Then, my lord, will kindly come to the judgment, page 82.
Judgment, we have seen it already.
No, para 9, my lord.
We have seen it already.
Yes. No, my lord. The para 9. The respondent had further stated that compensation is to be determined as per provisions of first schedule of the 13 Act and compensation is therefore paid at the rate of 10% of the market value, so determined as per MP Act. So they are oblivious of the fact that 2013 Act applies, but only when it comes to percentage, my lord, they are playing the trick.
This written statement.
Yeah, no, this is the part of the judgment.
Okay.
Then taking note of the respondent's contention. And here the respondent is arguing 2013 is an act for acquisition of land, therefore it does not apply. And what was considered by the learned district judge was, my lord, this submission of the Gail authority. Therefore, my lord, here is a case where, out of the page 66 of PSF, 66. And one more paragraph, my lord. Please come to page 66. This is part of their written statement. Kindly come to the last 3 sentences at page 66. Further, for the purpose of determination of land compensation against acquisition of right of user, market value is calculated as per provisions of the first schedule of the 13 Act. So all throughout their stand was, my lord, that 2013 Act applies. It is only in this honorable court, my lord, they are taking a U-turn, whether this is permissible. In my humble submission, it is not.
Then
Because-
why you filed an application under section 10(2)
No,
of
my lord.
PMP?
No, 10 read with that act.
Hmm.
Because the substantive provision is, my lord, section 10.
Hmm.
Because my calculation, but while assessing the market value, there you have to apply, my lord, 2039. That the 10% will go to 400%.
Hmm.
Lordship, note, my lord, this act has been considered to be a very progressive piece of legislation. Where, my lord, earlier, my lord, what the person used to get 1 rupee, now they are getting 4 rupees
Hmm.
for a compensation of the land.
Hmm.
And now there are several provisions have been incorporated. My lord, now it is not the, my lord, mercy and discretion of the acquiring authority. Now it is a case where a fair procedure has to be followed. End of the day, my lord, the landowners get a better deal. Now, when Parliament envisaged that even in case of PMP Act, by virtue of any order issued either under 105 or under 113, a removal of difficulties order can be passed, whereby provisions of 13 Act can be made applicable even to PMP Act. My lord, that has been done.
Where is that letter?
My lord.
Where's that letter by the
Ah. That letter is at page perhaps 67, Nikki. 73. 73, my lord.
Yes.
Page 73. 8, 11, 20.
This is by whom?
This is by the, my lord, competent authority.
Gail only. The
No.
respondent.
No. Competent authority is the officer of the state government, my lord. He was perhaps an ADC rank officer.
But it is under the letterhead of the Gail only.
Yes, because he was the competent authority, because under the act, an officer is appointed as a competent officer.
Okay.
So he was a deputy secretary to the government of some industry and commerce. Sajad Allah. So I have placed their written statement also, where they are clearly stating that compensation has to be paid under 2013 Act. Therefore, my lord, my humble submission to cut short the whole thing, my lord. The learned court of additional district judge was not competent to make a declaration that this removal order is bad, because that was nobody's case. Nobody has prayed for that. Number two, my lord, he has committed an error of law in denying relief to the petitioner in terms of 2013 Act. These are my two submissions. Therefore, Lordship will direct the authorities to compute the compensation as per the provisions of 2013 Act. Only in respect of the compensation component. Not based on 10%. Based on the provisions incorporated in the 2013. That's my only humble submission. Yes. That is my submission.
Heard Mr. Ken Chaudhary, Learned Senior Counsel, assisted by
A. Hussain, my lord.
A.M. Hussain.
A.
A.
for the
Hussain,
staff.
Learned Counsel for the and also heard Mr. D. Saikia, Learned Senior Counsel, assisted by Mr. R. Bor Pujari and B. Chaudhary. B. D. Chaudhary. For all the respondents, all. Saikia is for 3 and 4. H. Sharma from 3 and H. 1, 2, 3, 4. 1, 2. Yeah. Respondent 1. Who is for 2? We are 2, 3 and 4. 3 and 4. Revenue and Bordoloi. Then 6. 5 and 6. Then
I
non,
think five can be, a state government can represent because the deputy secretary.
yes, 5 competent authority.
Anyway, my lord, these are formal parties.
6, huh? Non appears for 5 and 6. This person. Yes, Mr. Sharma, what do you say? You are in between. You are neutral person. No, just want to hear your submission. What is your opinion? What is your view? No, on law point. Whether there is a difference between the acquisition of land and the acquisition user of what is called? Acquisition of right to user in land.
Right of just go by that PMP Act. Or
Huh.
by that act.
Then when
the electricity, when they are high power.
as per the yes, as per the when it is that this 2013 will apply in respect of this PMP Act. What is your opinion?
My opinion.
You don't have opinion. We'll
No,
record.
no,
We'll record that. The state of Assam has no opinion.
No, the 2013 Act will not apply.
You'll not apply. Your
Because
official,
you-
your
you
the
have
competent authority says otherwise,
So I
contrary to what you are submitting.
I am not representing the country.
Page 38. It's not a question of your representation. You are representing the state.
Rather, a writ petition should have been filed by the state saying how come that observation was made that 2013 Act applies. On the contrary, they are defending that order.
Okay. We'll record your submission, right?
As because Lordship, the electricity line, in that case, Lordship, the Telegraph Act is applicable. The compensation under the Telegraph Act is applicable.
That is beyond off the track. We are in India. We are not in Japan or Washington DC.
No, Lordship,
Sorry.
As an
I think you have decided not to make any submission. That's why you are sitting quiet there.
In case of
Okay, we'll not record anything.
Deeply,
The hearing concluded, judgment reserved.
deeply.
Just put it there, huh? And you kindly compile all this thing and then the separate this thing, including the act and other things, in a separate file or a separate this thing, file board or separate file cover. Huh? You put this thing here on me. Yeah.
I did 24.
What you will say?
May it please the Lord. Here also, my lord, the matter, my lord, regarding my lord, freezing of account. Freezing of bank account, my lord. The petitioner having an account with the board of bank, my lord, since 2024.
No amendment cost.
No, we have submitted.
Amendment cost title.
We have submitted.
When? 1/6/2026? When?
On 25/5, my lord.
25?
Lost.
There's nothing. Heard Mr. So-and-so, learned counsel for the petition, who submits that amended cost stated has already been has been filed. However, office note dated 01/06/2026 indicates that reflects that no amendment cost title has been received by the received. Next para, registry to verify. And if the amendment cost title is filed, do the needful. Just after 2 weeks.
My lord, short date, my lord.
What short date? You said so, but there's nothing. You have filed on 25.
25/5.
But the office note of 1st of June indicates that you have not filed. That's why we have asked.
First on Monday, my lord, in the meeting.
Not Monday. After 2 weeks.
Entire account.
After
has
10 days. After 10 days. Sorry.
No, in this case, I have a limited prayer, my lord, for consideration of the representation. Also, the facts of the case that in regard to the.
What
release of the-
representation?
My lord, may I
What
only
is
one
the
thing,
issue?
otherwise I think it will.
What is the issue?
My issue is that, my lord, in regard to the disbursement of amount for the land acquisition, my lord, case, we have put certain objection. And based on that objection, my lord, at page 41, the notice was issued to the respective parties, my lord, page 41. And afterward, my lord, what happened in between, once this proceeding was initiated, my lord, we have put a complaint on 17/2/2026, page 42, my lord. In the cause of action, ultimately, we have challenged the police on our court.
Heard, Mr.
Lordship, may I pray only one thing, my lord?
S. Maria, Land
My
Counsel
lord,
for the
limited prayer, my lord.
petitioner.
Page 42, Lordship, the disposal of this representation.
On the prayer of Mr.
Lordship.
Mr. H. Sharma, Land Counsel for the Land State Council. Further, 2 weeks time is granted
My lord,
to
what did my
obtain,
lord?
to
There is already delay, my
obtain
lord.
instruction as allowed by this court as per the direction, as per the order dated 11/05/2026. List after 2 weeks. Mr. So and so, your name please. A.K. Azad, the counsel for the
Kindly,
respondent
Lordship,
number.
may I pray for that?
Respondent number 3,
15.
3, 4 and 5 is present. Yes,
No,
you
let the
file.
instruction come from ultimately.
Let him file what's there.
No doubt.
Notice has been issued.
Notice has not been cleared. Yes.
You
Sorry,
cannot
sir.
stop him from
No,
filing.
But
Yes.
Lordship, otherwise,
You're
the
free.
it is possible to resolve once, my lord, this, my complaint will be entertained, my lord. I think both parties in presence, my lord, the authority can take call, my lord.
We'll see, let them obtain instruction. Dispose Kumaide. Huh? Huh. You have filed today. It's not on the record. It's on the record. Yes. Rejected. Not by this way. What is your prayer?
May I please, Your Lordship?
Huh?
Lordship, as per our.
What is your prayer here?
Prayer, Your Lordship, the petitioner entitled for the compensation as per the Assam Victim Compensation.
So you have approached the
Yes, Your Lordship.
that has been rejected.
Yes,
So
Lordship.
you file an
After
appeal.
file this writ petition.
Sure.
So
Ah,
there
heard.
is a provision for limit appeal, Your Lordship.
Yes, you file an appeal.
Okay, Lordship, liberty may be given because
Heard,
there is
Mr.
a
You will withdraw
definitive
the
line
you will withdraw the writ petition.
with liberty, Lordship.
Heard, Mr.
SI Akan.
S.I. Akan, learned counsel for the petitioner, submits that he may be allowed to withdraw this writ petition with the liberty to approach the appropriate authority. List of next para, Mr. Ardas, learned counsel for the petition. Respondent number 2 is present. Will not record anything since he's withdrawing. Huh? According to the writ petition, stands closed on withdrawal with the liberty and spirit for.
So, please.
45.
none appears for the petitioner on call. Nor no, not no. It says on call. The office note dated 12/02/2026 reflects that the petitioner has failed to take steps for service of notice upon response number 2. Despite issuance of notice, despite despite the order for steps by an order dated 14/02/2022. List of matter pertains to rejection of bid of the petitioner at the unpriced bid abolition stage. List of considering above, it appears that the petitioner is no longer interested to pursue the writ petition. Accordingly, writ petition is dismissed for non-presumption.
47.
I love this matter ought to have been listed for admission matter.
Hmm?
The matter ought to have been listed for admission matter.
Why? Every opposition files are placed.
Because last occasion, because.
Pleadings are completed.
It is completed.
Okay. It is submitted at the pleadings are completed. List for admission. After 3 weeks.
Date may be fixed, my lord, urgency.
3 weeks.
A date may.
Urgency is there.
Yes, my lord.
There is no urgency.
Yes, urgency is there because they have attached my garden, my lord.
Attach your
Attach my garden against the violating this honorable court's order. Attach my garden, tea estate. The respondent have attached my tea estate.
tea estate.
Yes, violating
Okay.
this.
Very bad. Why you have attached?
Violating this honorable high court's order, man.
Okay. After 3 weeks, you give the date.
If you have like.
25th. Yes.
So as far of this, not dated 15/5/26, the service is presumed to be complete.
Have you taken steps?
Yes, Lord.
When?
We have taken steps on 13/3/26.
13/3. It is submitted by MS
Skaloshkar. Skaloshkar.
SK
Loshkar.
Laskar, Learned Counsel for the petitioner. That steps has already been taken for service of notice upon respondent number 6. On
13/3/26.
13/03/2026. You are for?
Yeah.
Mr. So and so. Your name, please. S.S. Ahmed, Learned Counsel for respondent number 7 is present. In view of, let this matter be listed after 3 weeks. awaiting service report for respondent number 6.
Lordship, this matter may come up for admission. The respondent number 6 refused to accept.
We'll wait for some time.
As per office note, that is 18/5/26, my lord. As per number 6 refused to accept the notice, my lord.
Then why you have taken these steps?
No, step taken earlier, my lord. Thereafter, office note says, my lord, 18/5/26. Office note says he refused to accept notice as notice may be presumed to be served.
By which
18/5/26, my lord.
18.5?
26.
Okay, then why this has been letters has been given? Then you just delete all this, huh? Heard MS so and so learn SK. SK.
Yes.
SK learn consent person. It's in the order of Lajima Court dated 18/05/2026. Which reflects that the not answer notice on respondent number 6 as returned with remarked refused, huh? With an apostrophe, huh? Apostrophe. Refused. Mr. Does the service of notice upon respondent 6 is presumed to have been served and completed. List for admission after 3 weeks.
49.
Yes, Mr. Lordship. I have filed an additional affidavit today, my lord.
Huh?
I have filed an additional affidavit today, my lord. It is on record, Lordship.
It's in record.
Yes, Lordship. No.
In the additional. You want to reply?
This grievance was there because there is an order for filling the
No, whatever the additional affidavit.
That is what he is submitting, Lordship.
You want to reply?
No.
Already they have reversed.
Huh.
He has taken the stand. The stand he is taking the. They already reversed. So now it's okay. There is no grievance.
There's no grievance.
No, if it is reversed, then I have no problem, Lordship. The only thing with regard to IA number, Lordship, is another IA, Lordship, may kindly take up.
Yeah, why should go for IA when things are the main grievance is
There's
addressed?
2 banks, Lordship.
Huh?
There is 2 banks.
Huh?
There is 2 banks, Lordship. In the earlier IA, Lordship, the HDFC Bank was directed not to take any action against me, Lordship. And whereas they have taken some action, that's why I filed an additional affidavit, which my learned friend has said, no, they have reversed it now. And with regard to IDFC Bank, Lordship, yes, I have filed with this IA, whereby I need the protection so that no further coercive action should be taken against me because this is a case of cyber fraud, Lordship. And I have been subject to cyber fraud. So there has been an interim order passed by this court earlier, Lordship. Lordship may kindly take up my IA, Lordship. 1712, Lordship.
So who has to reply your IA? Who has to respond to your IA?
No, Lordship, it is.
Who has to respond to your IA?
IDFC Bank, Lordship.
Who is IDFC? Yes. What do you say?
Lordship, first thing that they have to prove that there is a, because they themselves has raised in the writ petition that they want in direction to the police thana concerned to register the FIR.
Lordship, may I take up my IA,
They
Lordship?
have filed an ombudsman application. That was also not convicted.
Then?
Your Lordship, then the.
See, why IA is something different. See,
Yes,
I'll tell you.
Yes, sir.
I mean, what is your grievance, main grievance?
Lordship, I have filed this writ petition, Lordship, on two grounds, Lordship. I have been subjected to cyber fraud. It is a specific case of the banks that there was a fraud involved. There was some crime happened, Lordship.
and proceeds of the crime has been taken out from my account. Now, Lordship, this is an admitted fact. They have themselves stated that yes, these transactions were fraudulent transactions. Subsequent to that, even then they said that this is a cyber fraud. They're trying to recover the money from me. That is why I filed a writ petition. Before filing the writ petition, I went to the Ombudsman, RBI Ombudsman, and the RBI Ombudsman has said that you have to pay the money back. Now that is absolutely illegal because this is a covered case, Lordship. This honorable court has already held that.
Why this is listed for orders?
For the IA, Lordship. That's why, Lordship, can you take up the IA?
Heard, Mister?
Lordship, can you take up the IA for a moment?
We'll decide the entire matter, sir.
Yes, Lordship. Yes,
Then?
Yes. Next week, Lordship.
What next week? Heard, Mister?
P. Deca, Lordship.
P. Deca, learned counsel for the petitioner. And also heard Mister M. Sharma, learned counsel for respondent. Who else are there? Also. 1, 2, 3. Who is for 1? H. Gupta for respondent number 1. Then and thus Lannister counts for 2, 4, 5. H does for respondent number and Mr. 7 and 8. And Mr. And Sharma for is agreed to by learned counsel for the parties. Let this matter be listed after 2 weeks for admission. For admission.
A date may be fixed, Lordship.
2 weeks you will give the date.
After 11.
I think we have picked so many matters on 26nd. Okay.
Lordship, let it be in the on a hearing date. It will be better, Lordship. If not 22nd, 23rd, Lordship.
No, it's not. It's not a hearing matter. So why you should take it on?
50 and 51.
Substitution of legacy of deceased respondent non appears for the applicant on call. Mr. N.C. Das, N. Das, London State Council, and Mr. R. B. BP Kakoti, London Council for respondent number 8 are present. List after 3 weeks. List these matters after 3 weeks.
Lordship, here the writ petition is accompanied by an IA. IA is for impleadment.
Huh?
The caveator is not present today.
Huh?
The caveator for whose impleadment the IA was filed is not present today.
So why?
Lordship may dispose of the petition and let us add the party respondent number 6.
Huh?
Lordship may dispose of this petition and add the respondent number 6 thereafter. Number 7.
Who has filed the? He has filed the caveat in the.
Yes, Your Lordship. So thereafter we file the impleadment as per the court's order.
Court's order.
Yes, Your Lordship.
Where
It's
is
on
the court order?
Page 11 of the IA, Lordship.
11 or 12?
Yes, Your Lordship. 11, 12.
Heard Mr.
A. Mishra, Lordship.
A. Mishra, learned counsel for the petitioner. Who else? You are also there. And also Mr. H. Sharma, learned state counsel for respondent number 3. Next, this is an application praying for impleadment of Srimati or Sri?
Sri, Lordship.
Asma Khatun.
No, Your Lordship. 7, next page. Rafiqul Islam.
Okay. Sri Rafiqul Islam. Son of, what is it? Chan Mia.
Yes, Lord.
of Birsing Part 3 Village PFP Pakirganj in the district of Dhubri, Assam, as party respondent in the connected WPC 218 of 2026. The next petitioner filed a connected writ petition. What is the challenging the rejection of your election petition? Rejection of election petition. In respect of what election?
This is panchayat election.
In respect of the election petition. Panchayat to the pursuant to explanation of panchayat election. In respect of election petition challenging the election respond number 6.
Yes, sir.
6 or 7?
6, Lordship.
Respond number 6, namely
Asma Khatun.
MS Asma Khatun. You just write, not sorry, huh? You just write what I said, last line. Filed a writ petition, connected writ petition, challenging the rejection of election petition, assailing the rejection of election petition with regard to the challenge of with regard to the challenge to the election of the respondent number 6, namely Asma Khatun. Huh? Christoph, who is this respondent number 7?
Respondent number 7 was included in the previous party as he had claimed that he had stake in the election.
Next
petition.
para. Considering the this court by an order that 24/04/2026 while issuing notice in the connected writ petition has directed the applicant writ petition to file approve the application for implement of the caveator list of who was a party in the election petition. Before this, you just write before that. Huh? The party sought to be implemented has filed a caveat in the connected writ petition. Was a party in the election petition. List of accordingly, then you read by an order that it's this court has allowed so and so to implement the so and so. Huh? Next, having considered about and considering that the having considered that the party sought to be implemented was a party in the election petition, and in considering that this court has already directed the applicant writ petitioner to file an application for implement of the caveat, I deem it appropriate to allow this application. Accordingly, the writ petition, accordingly, the Mr. So and so, respondent number 7 is Rafiqul Islam so and so to give detail, huh? Is allowed to be implemented. Party respondent number 7 in the connected writ petition. I stand alone disposal. Then in this writ petition, in view of the order passed in IA so and so, the learned counsel for the petitioner to file amended course title. Yes. Next para, on receipt of the amended course title, the registry to incorporate the newly implemented respondent number 7. Next para, the respondent, the learned counsel for the petitioner to take steps. Not the learned counsel for the petitioners to take steps.
And perhaps, Lordship,
You just huh?
perhaps notice was not served on the respondent number 6.
Ah.
The previous steps were taken. So matters may be listed after 4 weeks. Take steps.
List after 4 weeks.
Obliged, Lordship. 53.
May I please, your Lordship?
Yes, madam.
Lordship, as per the last order, we have taken our steps.
Huh. Services are completed. Okay. Hard Mrs. MS
B. Nandini.
B.
Nandini.
Nandini, learn counsel for the petitioners. Petitioner.
Yes, your Lordship.
Petitioner. Next para. Mr. A. Patar. Patar. Patar, learned counsel. Enters appearance on behalf of private respondent number 5 and 6. And prays for 3 weeks time to file affidavit in opposition. Mr. You are appearing for all. Mr. D. Permanent Learned Standing Counsel, Health and Family Welfare Department. Also prays for 3 weeks time to file affidavit. To produce the record. But for some time to produce the record, Prayers is allowed. A prayer of the learned counsel, learned counsel response is allowed, List after 4 weeks, 3 weeks.